filing the written
All right.
submissions and this list of
With your
citations.
lordship's indulgence, may I mention a
But,
matter?
I am permitted to make one mention after puja vacation for making a list.
Please give your slip.
It's a matter, tender matter, your lordship.
Yes,
Please give. Please give. Please give.
The lordship's permission. State Council, my senior Mr. Gopal Jain is online.
Which item?
Item 39. In fact, the state government was directed to file a counter affidavit. So there, I think
Today I'm filing, I have already solved.
my learned senior Gopal Jain is there.
Yes.
Lord, item 25 and 39.
Yes.
Lord, am I audible?
Yes. Yes.
Yes, Lord, can I mention item 25 and 39 to be kept on any date of my lord's convenience for hearing?
Yes. That will be done. Let the matter.
Whatever, my lord, and if it's at 2 p.m., then we can assist my lords to hear the matter itself.
All right, we will fix a date. Let the matter be called first.
Very well, my lord.
Item number 42, my lords. Item number 42, I received a counter.
Yes, my lord, if it could be sometime at
Let the matter be called, Mister. Let it be called.
Lords, I have another prayer. It says review application, this is the fourth memo I'm filing. It will become instructions. Then it has to be composed with
All right.
Justice G. Satpathy.
All right, let me test. When did you file your last memo?
Last memo I filed 4 days back.
And what happened?
Nothing, the bench has not been, your lordship is to constitute that bench.
Let me see what is there.
Order has been passed against me in a matter where I was
Just
not a
a
party.
minute, just a minute.
It may have been fixed, that's.
All such matters, the benches are required to be constituted. Benches are being constituted.
Lord, I have written specifically in the memo.
Yes. I personally see those memos.
Supplementary list item number 1. Sorry, item number 2. Supplementary list item number 2, sir.
Just
Lordship, Mr. S. the senior advocate is just reaching for
because they
order.
are waiting.
Yes. Lordship, can I take a passover for 2 items?
That's
If sir is okay with it.
all right. We are waiting. It will take hardly 1-2 minutes.
If your lordship can take up the matter after two matters, your lordship.
Difficult.
Or after the orders items are taken up. your
Oh,
lordship.
this is not done. And when the matter was directed to be listed at 10:30 and your senior is not here, then not good.
You have the judgment.
Yes, your lordship, I have those.
Try them.
How are you?
Yes, please place the decisions.
Your Lordship, the first judgment that we are citing today is a judgment of 2004 passed by the Honorable Supreme Court of India. If Your Lordship may kindly refer to para number 8. I may read it, Your Lordship.
Yes, yes.
When the court has to decide the question of jurisdiction pursuant to an ouster clause, it is necessary to construe the ousting expression or clause properly. Often, the stipulation is that the contract shall be deemed to have been made at a particular place. This would provide the connecting factor for jurisdiction to the courts of that place in the matter of any dispute on or arising out of that contract. It would not, however, ipso facto take away jurisdiction of other courts. When an ouster clause occurs, it is pertinent to see whether there is an ouster of jurisdiction of other courts. When the clause is clear, unambiguous, and specific, accepted notions of contract would bind the parties, and unless the absence of ad idem can be shown, the other courts should avoid exercising jurisdiction. As regards construction of the ouster clause, when words like alone, only, exclusive, and the like have been used, there may be no difficulty. Even without such words, in appropriate cases, the maxim expresso unius est exclusio alterius, expression of one is the exclusion of another, may be applied. When what is an appropriate case shall depend on the facts of the case. In such a case, mention of one thing may imply exclusion of another. When certain jurisdiction is specified in a contract, an intention to exclude all others from its operation may in such cases be inferred. It is
Please let her
therefore
argue. She is arguing arguing better than any other senior counsel.
Well,
Please allow her. Please place.
Continue,
Please
continue.
place your.
He has earned your fees today.
Yes, that is the judicial opinion.
Let us.
Yes.
Your Lordship, what we are trying to place through this judgment is that since the Integrity Pact, which specifies about New Delhi being the head office of the principal place of business or the head office of NHAI, the words alone, only, or exclusive have not been used in that particular clause. Because these words have not been used, it can be construed that Delhi is not the only jurisdiction where the matters have to be entertained or the matters have to be heard.
Yes.
Yes. And the jurisdiction is not confined to New Delhi only.
Yes.
There is no, it does not mean that there is that is an ouster clause of jurisdiction, and all other courts also will have jurisdiction where this matter can be heard. There are certain other judgments also which we would like to place, Your Lordship, which are also on these lines.
Yes. Yes. You can just all right. Let it. Yes, any other decision?
Yes, Your Lordship. Passed on another judgment, Your Lordship. This is a judgment of the year 1989, passed by the Honorable Supreme Court of India. If
Yeah.
Your Lordships may kindly come to para number 21.
Yeah.
From the foregoing decisions, it can be reasonably deduced that where such an ouster clause occurs, it is pertinent to see whether there is any ouster of jurisdiction of other courts. When the clause is clear, unambiguous. Yes, clear, unambiguous, and specific accepted notions of contract. Your Lordship, we would like to emphasize on the words clear and unambiguous. This would also take us back to the previous judgment where we have seen that the words only exclusive, unless those words are used, Your Lordship, we cannot say that it is unambiguous. And if those words are used, we can say that the jurisdiction is confined to a particular place. But since these words have not been used, even in the integrity pact nor in the agreement, the contract that has been signed between the petitioner and NHAI, we cannot say that the jurisdiction is confined to New Delhi. I would continue, Your Lordship. As regards construction of the ouster clause, when words like alone, only, exclusive, and the like have been used, there may be no difficulty. Even without such words, in appropriate cases, the maxim expressio unius est exclusio ulterius, expression of one is the exclusion of another, may be applied. This is exactly on the same lines as the 2004 judgment that I first read out, Your Lordship. There is what is an appropriate case shall depend upon the facts of the case. In such a case, mention of one thing may imply exclusion of another. When certain jurisdiction is specified in a contract, an intention to exclude all others from its operation may in such cases be inferred.
Yes.
There is one last judgment, Your Lordship, that we would like to place. 1995.
Yes.
Lordships, the third judgment is a judgment of the year 1995.
Yes.
Your Lordships may come to para number 5.
Yes.
I may read, Your Lordships.
Yes. Please.
So normally that court would also have jurisdiction where the cause of action wholly or in part arises, but it will be subject to the terms of the contract between the parties. In this case, clause 21 reads thus: this work order is issued subject to the jurisdiction of the High Court situated in Bangalore in the state of Karnataka. Any legal proceeding will, therefore, fall within the jurisdiction of the above court only. In this case, Your Lordship, the word only has been used, which is why the jurisdiction of Bangalore in the state of Karnataka will have jurisdiction. This is a clear intention between the parties to confine the jurisdiction to Bangalore, which is why the words only have been used. A reading of this clause would clearly indicate that the work order issued by the appellant will be subject to the jurisdiction of the High Court situated in Bangalore in the state of Karnataka. Any legal proceeding will, therefore, be instituted in a court of competent jurisdiction within the jurisdiction of High Court of Bangalore only. The controversy has been considered by this court in ABC Laminate Private Limited versus AP Agencies Salem, the judgment that I just placed before this judgment, Your Lordship. Considering the entire case law on the topic, this court held that the citizen has the right to have his legal position determined by the ordinary tribunal, except, of course, subject to contract A, when there is an arbitration clause which is valid and binding under the law, B, when parties to a contract agree as to the jurisdiction to which dispute in respect of the contract shall be subject. This is clear from section 28 of the contract, of the Contract Act. But an agreement to oust absolutely the jurisdiction of the court will be unlawful and void, being against the public policy under section 23 of the Act. We do not find any such invalidity of clause 21 of the contract pleaded in this case. On the other hand, this court laid that where there may be two or more competent courts which can entertain a suit consequent upon a part of the cause of action having arisen therewith, if the parties to the contract agree to vest jurisdiction in one such court to try the dispute which might arise as between themselves, the agreement would be valid.
Yes.
If such a contract is clear, unambiguous and explicit and not vague, it is not hit by sections 23 and 28 of the contract.
Yes. That's all, Mr.
But now, I'm sorry for the delay, but I'm really happy that my learned friend would have placed the matter. Better than what I've placed.
Can you improve
Yes, not
beyond what has been argued?
just taking the factually, my lads.
Yes. Place the decisions, analyze the law laid down by the Supreme Court in various cases, in at least the 3 cases. What else is required to be argued? Now?
Well, only factually, I just want to show only 2-3 aspects, my lad. The one that has been shown by my learned friend yesterday regarding ouster of the jurisdiction of this honorable court. That is neither, my lord, unambiguous. I mean, that is ambiguous.
That is what she was arguing.
Yes, well, that
That is ambiguous.
Yes, factually, I just want to establish that, my lord. And Lordship may kindly see that paragraph, that page 119, as was shown by my learned friend yesterday in the counter affidavit.
Yes.
And then, my lord, the approach to Delhi High Court. My lord, before going to page 119, the Delhi High Court was approached under Section 9 of the Arbitration Conciliation Act for an interim order because of the termination of the contract. It is not that the termination part was challenged before the Honorable Delhi High Court and the blacklisting matter is challenged before this Honorable Court. And why? Let me put a question to myself as to why did I approach the Delhi High Court for the purpose of Section 9, my lord. Here, Lordship will see page 79 of the brief.
Yes.
My lord, in this arbitration 8.2,
Yes.
but this is the procedure which Millard ought to take over while the arbitration commences. Millard 8.2.5 small a. In any arbitration proceeding hereunder, the proceeding shall, unless otherwise agreed by the parties, be held in Delhi. That means the place of the seat of the arbitration will be at Delhi. If the seat of arbitration is at Delhi, my lord, then obviously the Section 9 application or Section 11 application has to be placed in Delhi. That is the reason for which, my lord, we moved the Section 9 application before the Honorable High Court of Delhi. Now, my lord, let me take your lordship to that page 119 with regard to the jurisdiction part, my lord.
Yes.
Net 290.
Yes.
I'm sorry, not 219, but running page 32 of not internal page 32 of the counter affidavit filed by them, my lord. My lord, reliance have been placed on Article 10 for the purpose of exclusion of the jurisdiction. My lord, 1. This pact is subject to Indian law, full stop. Place of performance. My lord, admittedly, the place of performance is here in Odisha, from Chandikhol to Duburi, the 4-line expansion, my lord. Place of performance and jurisdiction is the registered office of the principal at New Delhi. My lord, this certainly cannot be construed, my lord, that the courts in Delhi will be having jurisdiction.
Yes.
It says, my lord, the registered office of the principal at New Delhi. So, my lord, even if, my lord, this clause, when the performance is in Mila Odisha, that certainly cannot be in Delhi, my lord. And the jurisdiction is the registered office of principal New Delhi. My lord, I don't understand the meaning of this, my lord. So, this is not, my lord, clear from, free from ambiguity.
So whether this word performance
Yes.
has been used anywhere in the pact?
No. No, my lord. But the pact starts from page, my lord, internal page 29, 216.
Yes. We will see.
So, my lord, in this context, my lord, what law is very clear, my lord, there is no ambiguity to the extent that if the courts in two different places are having the jurisdiction,
Yes.
then the parties by agreement confine to one place. Conferment is not permissible, because if that happens, it will hit by section 23 or 28 of the Contract Act, my lord. But here there is no confinement as such. So that is the reason, my lord.
Yes.
It is quite preposterous, with due respect, my lord, to say that this honorable court is.
If you say that preposterous, then if we uphold their contention, then you may say the judgment also to be preposterous. Yes.
Well, why is it, my lord? The exact meaning of that, my lord, is out of anxiety. For the preposterous is that, so out of anxiety, if it is said.
Let us see the meaning of preposterous.
Yes, basically, my lord, that.
Let us see.
Yes, something is completely unreasonable and contrary to reason, nature, and common sense.
I think by Google Milord, it's such that you should laugh at. Milord.
Yes, exactly.
In my Google Milord, I'm sorry if I say it is slightly different. It says silly, ridiculous.
Ridiculous.
So which meaning did you mean?
I will not say silly.
Sorry.
I will not say silly or ridiculous.
All right.
Because it is similar sort of thing, my lord.
All right.
Yes, my lord.
Yes.
So that is the reason, my lord, I would humbly submit, my lord, that the submission with regard to that this honorable court doesn't have the jurisdiction, or is denuded of the jurisdiction because of this clause, my lord,
Yes.
doesn't, my lord,
We will.
get substantiated
Yes.
because of these three judgments, my lord.
That means when we asked Ms. Mishra for the judgment, somebody has given us this. It's not her.
I have passed it.
Well, can I have the look at the judgment? my lord?
No, this is nothing. That's a different point altogether. That judgment was rendered by B here, sitting in my arbitration jurisdiction. I was just seeing
On
that.
that point.
Yes. And with regard to the argument that was being, the judgment that was cited yesterday of the Honorable Supreme Court, my lord.
राष्ट्रीय इस्पात निगम.
That is, my lord, Rashtriya Ispat, my lord. But what the Honorable Supreme Court of India was called upon to decide in that case was interpretation and application of Section 8 of the Arbitration Conciliation Act, my lord. But there was a suit filed, my lord. The judgment which was being read upon yesterday by my lord and friend. And that was an agreement, my lord, concerning handling and storage of storage at Ludhiana. But the suit was filed with a prayer to restrain the blacklisting and termination part and to get an order of status quo when blacklisting and the termination had happened. And the termination and blacklisting happened simultaneously on the very same day in that case, malad. In the case at hand, malad, this honorable court was approached on 13th of June. These dates are quite important, malad. I'm just handing over, malad, the Lordship will see, malad.
Yeah.
On 13th of June 2023, this honorable court was approached.
Yes.
This honorable court was approached because of the blacklisting order, and the blacklisting order was passed on 5th of June 2023 at page 162, malad. Blacklisting was on 5th of June 2023. I approached without loss of time on 13th June 2023, malad. And the termination had happened on 17th May 2023, for which Section 9 application before the Honorable Delhi High Court, and that is 3 days after I approached this Honorable Court. That was on 16th of June 2023.
No, 13th of June you filed.
13th of June, this Honorable Court.
Yes. And
Section 9 application before Delhi High Court on 16th of June. And termination happened on 17th May 2023. And backlisting happened, malad, on 5th of June 2023.
Yes.
And the judgment cited before your Lordship yesterday, in that case, factually, the blacklisting termination happened simultaneously on the same day. And suit was filed to restraining a blacklisting and termination from happening, malad. And then, malad, the suit was held to be, the Section 8 application was filed. The Learned Trial Court held the suit to be maintainable for the simple reason that the respondents there, defendants there, had filed their written submission, written statement. Matter went to the Delhi High Court. Delhi High Court took the similar view. But then when the matter came to the Honorable Supreme Court of India, malad, Honorable Supreme Court held that when an interim order was passed by the trial court, and also a move is made to defend, to nullify the interim order, then a stand is taken before the Delhi High Court, before the trial court. So that that cannot be taken to be understood as a step in the proceeding, or, my lord, before filing of the defense. So that is the reason, my lord, the Honorable Supreme Court said, no, that itself cannot be a ground, in fact, to say that they have submitted to the jurisdiction by the filing the written statement. So they are debarred from raising the plea. In that context, my lord, your Lordship will see it in that judgment at page 285, paragraph 22. In paragraph 22, my lord, the Honorable Supreme Court of India relies upon an English judgment, and the English judgment is quoted, which has been accepted also. If a lordship me, my lord.
Yes.
The scope and purport of such a clause was considered in Heyman versus Darwin's Limited, and it was stated the answer to the question whether a dispute falls within an arbitration clause in a contract must depend on what is the dispute and what dispute the arbitration clause covers. And again in para 23, my lord, last sentence. What is necessary to be looked into, therefore, inter alia, would be as to whether the subject matter of the dispute is covered by the arbitration agreement or not. Then, my lord, taking all this into consideration, and lordship will see again at paragraph 29, page 287. So far as the question of blacklisting is concerned, an error was committed by the High Court in opining that the respondent firm had been blacklisted without issuing any notice. In fact, from a bare perusal of the notice dated 23rd of May 2002, it appears, upon recital of the relevant facts, it was stated, in view of the above, before taking a final decision on blacklisting you and debarring you from participating in tender floated by RINL VSP or entering into an agreement with RINL VSP, you are hereby called upon to explain as to why you should not be blacklisted and debarred as mentioned above. You may submit your explanation within 7 days or receipt of the notice. In case we do not receive your explanation within the above mentioned period, it will be presumed that you have nothing to say in the matter and the decision of further suitable action will be taken accordingly. No final decision had therefore been taken. So, my lord, here, in this case, there was no final decision taken with regard to blacklisting. It's just a notice. And that is the reason of taking the entire factual scenario into consideration. The Honorable Supreme Court observed at paragraph 43. The submission of the learned counsel.
Yes.
The submission of the learned counsel for the respondents that the two different causes of action having been raised, namely illegal termination of contract and blacklisting of the firm, Section 8 of the Act was not attracted is devoid of merit, inasmuch as accordingly to the respondents themselves, both the causes of action arose out of the terms of the contract. What was necessary was to consider the substance of the dispute. Once it is found that the dispute between the parties arose out of the contract, then Section 8 would be attracted. So, my lord, then it has to be seen what really is the dispute about. Now, my lord, in this context, I was taking your lordship to page 126 yesterday, my lord. Lordship, kindly come to page 126. My lord, it is a notice to show cause. And in the notice to show cause, my lord, a lordship will find at page 127, paragraphs 4 and 5. It is observed that the authorities engineer has failed to comply with the above contractual obligation and made gross error while recommending payment of the contractor to the authority. Due diligence was not observed while recommending the contractor payment. In view of the above, it is requested to submit your explanation within 7 days from the issuance of this letter as to why disciplinary action shall not be taken against the authorities engineer for the lapses made in recommending the excess payment of the contractor. Well, the show cause notice does not indicate that we are going to why you should not be blacklisted.
Oh, this so-called notice is to whom?
It is to me, my lord. It is by National Highway Authority to me, my lord. Then I submit an exhaustive reply.
No, just a minute. Who is authority? You are engineer.
I am the engineer consultant, my lord.
All right, yes.
My lord, this was exhaustively replied to. In the reply, I made a mention that whatever payment had been suggested by me, it was only at the behest of National Highway Authority. And it was I, my lord, who was registering the payment and who was saying at every point of time the measurement has not been given properly by the contractor.
All right, all right.
And then, my lord, Lordship will
All
see the at 162.
No,
That
we
is-
will not enter into the merits unless we will decide that maybe in piecemeal. We will decide first of all the maintainability and then if required, we shall enter into the
Well,
merits.
Yes, well, this is also for the purpose of showing to Lordship, my lord, that is it covered by the arbitration? For that purpose also, my lord. Now, my lord, after the show cause notice,
Yes.
then my lord, I was slapped with the blacklisting order at page 162.
Yes.
What they say in this, my lord, that this blacklisting order is not as per the contractual terms. They say it is in view of their internal circular. That means the blacklisting.
Mr. Yesterday also,
Yes.
we had opined that for blacklisting, there is no requirement of
My lord,
such provision in the.
I agree, my lord. I agree, my lord.
Therefore, if the blacklisting is done by a party with whom you had a contract, the party says that henceforth, I will not take your services. He has a right. Now, since it is state, therefore, state has a duty to give you opportunity for that organization only.
Well,
All right, you are blacklisted. That blacklisting has the effect that others may also decide not to take work from you
yeah, my lord,
because of that. So
let me answer.
therefore-
Let me answer to my lord's query.
Therefore, you don't have to reiterate that point that because blacklisting was not there in the agreement, therefore you cannot be blacklisted. You don't have to repeat that.
That's the other the converse I'm arguing, my lord. Just the converse. What I'm submitting before Lordship, my lord. If there is no clause with regard to blacklisting in the contract as such, then I certainly cannot raise this question. But when the parties agree that yes, there is and for that reason there is a clause in the blacklisting in the contract itself. If the contract doesn't have a blacklisting clause, fine, my lord. I am before Lordship because of the contract only. But if the contract specifies blacklisting, could they do it otherwise than what is mentioned in the contract?
All right. So where is the blacklisting clause?
That is clause 9 of the contract, my lord. At page 673.
Yes.
Not page 73, my lord. They have a, my lord, clause for blacklisting at page 73, clause 9.
So more so you should go for arbitration
My lord,
because it is part of contract.
my lord, that section 9 application, in fact, arbitrator appointed, it is over.
That is your.
Well, that is a
See,
well-
it is the arbitrator to decide whether.
my lord, which again, do respect, my lord, the arbitrator would only decide with regard to termination. That is the reason I went for termination, my lord.
Difficult. All right, let us see your page 73.
Clause 9, my lord. Lordship with me, my lord.
Yes.
In any case of fake, incorrect, inflated CV is found, it shall be dealt with very severely and would result in all possible penal action, including blacklisting from the future projects of NHAI. Otherwise than this, my lord, there is no provision anywhere in the contract regarding blacklisting. And what they say, my lord, now in their impugned letter, my lord, in termination, In debarment, my lordship will see at page 162, I'll take lordship again, my lord. At page 162, my lord, they take the help of my lord.
So this is your submission
Yes,
that beyond the grounds mentioned in clause 9,
yes,
you could not have been blacklisted.
quite right.
That we will consider.
And they have lordship, only two aspects I'll just raise, my lord. I'll conclude my argument thereafter. In the blacklisting order, so when they slapped me with that order at page 164, they rely upon their own internal circular. And the internal circular, my lord,
Sir,
was of-
the question is of maintainability, and you are taking us to the merits of the
again onto arbitration, my lord.
sustainability of the
Maintainability vis-a-vis the arbitration, my lord. Maintainability vis-a-vis arbitration, I'm not going to any other aspect, my lord.
All right, yes.
My lord, and Annexure 23, my lord, that policy. My lord, is a policy of 18th of January 2022. My lord, if my agreement, my lord, was on 11th December 2019. In my agreement, there is only, they have mentioned about blacklisting, and now they rely upon a policy, internal policy, which is of 18th of January 2022. And
Yes.
lordship will see in the internal policy at page 169. Paragraph 7. Before deciding an AE, IE, those subdivisions, my lord, as a non-performer or debarring stroke penalizing it, the concerned technical division shall issue a notice to the so-and-so by giving a 15 days time to furnish its written reply and allow personal hearing if so desired by so-and-so. And such notice shall not be issued without the approval of an officer not below the rank of Chief General Manager. And this is something of the year 2022, my lord. And it says notice to be given. Again, that is the realm of my lord, merit. I am not going into it. But they have taken this in isolation by issuing this slapping order, this blacklisting order by taking this, the help of this, my lord, because they themselves know, my lord, blacklisting does not come under, my lord, the arbitration. That is the only reason for which they have taken the help of this particular circular. And again, if a lordship looks into the arbitration, my lord, as I was showing to the lordship yesterday, my lord, 2 point 9.6 at page 59. If either party disputes whether an event specified in paragraphs A to E, that is, the events are specified, my lord, they are crystallized in the agreement itself. To paragraph A through E of the clause GC 2.9.1 or in clause GC 2.9.2. But if a lordship looks at A to E of 2.9.1 and lordship from at page 53, that is regarding termination. And 2.9.2, that is not regarding by the, if the consultant will not terminate, it's only termination. Such party may within 45 days after receipt of notice of termination from the other party, refer the matter to arbitration pursuant to clause 8 hereof, and this contract shall not be terminated on account of such event, except in accordance with the terms of the resulting arbitral award. So arbitration would be confined to only termination either by the NHII or by the consultant, and then it will be referred to the arbitration balance. Because the clauses have been crystallized in this arbitration agreement itself, and that is the reason, my lord, possibly they have not they have issued the blacklisting order taking the help of the internal circular, my lord. And with regard to internal circular, my lord, that is the judgment of the Honorable Apex Court. It doesn't bind your lordship, my lord, or any court of law, my lord. Paragraph 6, I'm reading out. Circulars and instructions issued by the board are no doubt binding in law on the authorities under the respective statutes. But when the Supreme Court or the High Court declares the law on the question arising for consideration, it would not be appropriate for the court to direct that the circular should be given effect to, and not the view expressed in a decision of this court or the High Court. So far as the clarification circulars issued by the central government and of the state government are concerned, they represent merely their understanding and the statutory provisions. They are not binding upon the court. It is for the court to declare what the particular provision of the statute says, and it is not for the executive. Looking at from another angle, circular which is contrary to the statutory provision has really no existence in law. So, my lord, with regard to the arbitrability again of the blacklisting, I would humbly submit, my lord. My lord, blacklisting can happen if either there is a statutory provision, whether, my lord, as a legislation or subordinate legislation, or two, my lord, if there is a circular or order which has the effect of law under Article 13, Clause 3 of the Constitution of India, or third, my lord, if the parties have agreed with regard to if such circumstance happens, then a party could be blacklisted. But here, none of the three is present, and this blacklisting, especially, that is the reason for which it is not within the ambit of arbitration. With this, I would humbly conclude, my lord, that there is no ouster of jurisdiction of this honorable court, and this blacklisting is not arbitrable, because what is arbitrable has been crystallized in the contract itself.
On Monday. For orders.
Today.
Yes.
This judgment which my learned sister cited, Honey Lera, Honey Lera 2004 is similar. A 3 bench, this is latest, I think, 2039 SSC. Your Lordship, all those earlier judgments on the question of jurisdiction has been dealt with. Lord, here the question was in Swastik Gas. It was a company under Indian Oil Corporation. There was an agreement which was signed in Jaipur, but courts in Calcutta were given the jurisdiction to try the disputes. Lord, it's a very interesting judgment. Your Lordship may kindly have a glance. I have passed on. Not all the earlier judgments on the issue they have been discussed. Lord, it's a 3 judge bench with Justice Lokur concurring with Justice Lodha's view. Lord, the para 2, the fact, just 2 lines below.
Yes. This is the judgment which has been taken note of by me in that arbitration.
Yes, Honey Lera has been taken note of. All this The other judgment which my learned sister cited, ABC laminate, that has also been 1989, 93, all my lord,
Yes, sir.
13 earlier judgments they have been taken care of. Only 2-3 paragraphs, my lord, may I just draw your lordship's kind attention. My lord, para 8 of the judgment. The jurisdiction clause 18 in the agreement is as follows. My lord, at page 37 of the report your lordship would find. Jurisdiction. The agreement shall be subject to jurisdiction of the courts at Kolkata. The contention of the London Council for the appellant is that even though clause 18 confers jurisdiction to entertain disputes inter se parties at Kolkata, it does not specifically bar jurisdiction of courts at Jaipur, where also part of the cause of action has arisen. It is the submission of the London Council that except execution of the agreement, which was done at Kolkata, though it was signed at Jaipur, all other necessary bundle of facts forming cause of action have arisen at Jaipur. This is for the reason that the regional office of the respondent company is situated at Jaipur. The agreement was signed at Jaipur. The consignment agency, all those things were done at Jaipur. But the terms of the agreement says that the jurisdiction would be at Calcutta. So on the other hand, para 10. So therefore the council contended that the particular thing which is being argued by the other side, he vehemently contended, the para, the London Council for the appellant would submit, from there the last 3 lines, contended that clause 18 of the agreement cannot be construed as an ouster clause because the words like alone, only, exclusive and exclusive jurisdiction have not been used in the clause. The very same argument has been repealed. Even in Hanilera, that has been repealed. That has been referred to in para. I'll point out that, In Hakim Singh, on the other hand, the London Additional Solicitor General for the company stoutly defended the view of the designated judge that from clause 18 of the agreement, it was apparent that the parties intended to exclude the jurisdiction of all courts other than the courts at Kolkata. Here they say that it would be at Delhi, the performance and all other things from the agreement. In Hakam Singh, one of the earlier cases of this court wherein this court highlighted that where 2 courts have territorial jurisdiction to try the dispute between the parties, and the parties have agreed that disputes should be tried by only one of them, the court mentioned in the agreement shall have jurisdiction. The principle has been followed in many subsequent decisions. All those case laws have been discussed. I am not going in detail. This Hanilera has been referred in para 18 of the judgments. The decision which was cited by the other side. In Hanilera Textiles, this court was concerned with the question of jurisdiction of the Court of District Judge Delhi. Condition 17 in the purchase order, in respect of jurisdiction rate, legal proceeding arising out of the order shall be subject to the jurisdiction of the courts in Mumbai. So therefore, it was held that the Mumbai court alone shall have jurisdiction, not Delhi, because though it was signed in Delhi, Milan. All the following Hakam Singh, ABC laminate, Anzile insulations, it was held in para 9 of the report as under. Clause 17 says any legal proceeding arising out of the order shall be subject to the jurisdiction of courts in Mumbai. This clause is no doubt not qualified by the words like alone, only, or exclusively. Therefore, what is to be seen is whether in the facts and circumstances of the present case, it can be inferred that the jurisdiction of all courts except courts in Mumbai is excluded. Having regard to the fact that the order was placed by the defendant at Bombay, the said order was accepted by the plaintiff at Bombay, advance payment by the Bombay. As per the plaintiff's case, the final payment was to be, there was a clear intention to confine the jurisdiction of the courts to the Bombay, exclusion of all other courts. The Court of Additional District Judge Delhi had therefore no territorial jurisdiction. That is the jurisdiction of the courts of Mumbai. So therefore they held it would be Mumbai. I don't think how this judgment helps them. It is rather held to the contrary. So your lordship may straightway now come to para 30, 1. Para 31, may I read only last 5 lines, Miller? The question is, last 5 lines. The question is, whether parties by virtue of clause 18, my lord, which I read earlier, of the agreement have agreed to exclude the jurisdiction of the courts at Jaipur, or in other words, whether in view of clause 18 of the agreement, the jurisdiction of the Chief Justice of the Rajasthan of High Court has been excluded. For answer to the above question, we have to see the effect of the jurisdiction clause in the agreement, which provides that the agreement shall be subject to jurisdiction of the courts at Calcutta, Kolkata. It is a fact that whilst providing for a jurisdiction clause in the agreement, the words like alone, only, exclusive or exclusive jurisdiction have not been used. But this, in our view, is not decisive and does not make any material difference. The intention of the parties by having clause 18 in the agreement is clear and unambiguous, that the courts at Calcutta shall have jurisdiction, which means that the courts at Kolkata alone shall have jurisdiction. It is so because for the construction of jurisdiction clause, like clause 18 in the agreement, the maxim expressio unisas, the same maxim, my lord, which they read out, comes into play, as there is nothing to indicate to the contrary. This legal maxim means that expression of one is the exclusion of another. By making a provision that the agreement is subject to the jurisdiction of the courts of Kolkata, the parties have impliedly excluded the jurisdiction of other courts, where the contract specifies the jurisdiction of the courts at a particular place, and such courts have jurisdiction to deal with the matter. We think that an inference may be drawn that parties intended to exclude all other courts, my lord. So it is by implied contract. A clause like this is not hit by Section 23 of the Contract Act at all. Such clause is neither forbidden by law, nor it is against the public policy. It does not offend Section 28 of the Contract Act in any manner. The above view finds support from the decisions of this court in Hakam Singh, which is the first judgment on the issue, my lord, 1971 Supreme Court. So then comes ABC Laminate, cited by the other side, RSTV Finance, Angiel Insulations, Sairam City, Honilera Textiles, and Balaji Coke. The same view, my lord, has been consistently. It's a three-judge bench. So, my lord, that is in the above view. In view of the above, we answer the question in the affirmative and hold that the impugned order does not suffer from any error of law. The civil appeal is accordingly dismissed with no order as to cause. The appellant shall be at liberty to pursue its remedy under section so and so in the Calcutta High Court. So Justice Lokur has also concurred. My lord, about the blacklisting clause, your lordship was right. Patel Engineering is the leading case on this subject. Even if that is absent, even let us assume that this particular thing is absent in the contract.
No, in the first case, which was decided by the Supreme Court, there was no such clause.
No such clause. My lord, Patel
Only-
Engineering also same thing. Yes. 75 Supreme Court, I think, was the first judgment I was citing once also, my lord. I am
That
forgetting.
BSNL matter.
My lord,
BSNL
this
case.
is with regard to NHI again.
No,
Patel
no,
Engineering
that was-
versus
that
Union
was
of
first-
India.
first-
My lord, that must have been referred here because it's a
Justice.
2012 judgment. Let me just find out. Jagdish, that is, I think, 75. My lord, I had cited that particular judgment once. I am forgetting. My lord, I will find out. Lord, Arusian
No,
equipment.
there is no confusion about that. It's a kind of decision which a party to a contract takes, that in future I will not have any
Right.
relations
The
with
same
you.
thing, para
It's
25.
kind of that.
Yes, para 25 and 27. 24 and 25.
All right. Monday for orders.
Lord, here the same contention was raised. There is no blacklisting clause, so therefore they can't invoke.
Which
Lord,
one?
Milord, para 24,
Of the swastika? Yes.
Milord, 260 Portal Engineering.
Oh.
Portal Engineering. 2012, 11 SCC 257. This second respondent, yeah, 23, Milord, should I read? May I read, Milord? 23 before 24. The authority of the second respondent to enter into contracts, consequently the concomitant power not to enter into a contract with a particular person, does not flow from Article 298, as Article 298 deals with only the authority of the Union of India and the states. The authority of the second respondent to enter into a contract with all the incidental and concomitant powers flows from Section 3(1) and 2 of the National Highway Authority Act. Well, the same authority is here. Section 3(1) and Section 2 of the National Highways Authority of India Act 1988. It's a statutory body, created under a special law. So, the nature of the said power is similar to the nature of the power flowing from Article 299 of the Constitution, though it is not identical. So, the second respondent, being a statutory corporation, is equally subject to all constitutional limitations which bind the state in its dealings with the subjects. At the same time, the very authority to enter into contracts conferred under Section 3 of the National Highway Act by necessary implication confers the authority not to enter into a contract in the appropriate cases within bracket blacklist. The bid document can neither confer powers which are not conferred by law on the second respondent, nor can it subtract the powers which are conferred by law either by express provision or by necessary implication. The bid document is not a statutory instrument. Therefore, the rules of interpretation which are applicable to the interpretation of statutes and statutory instruments are not applicable to the bid document. Therefore, in our opinion, the failure to mention blacklisting to be one of the probable actions that could be taken against the delinquent bidder does not by itself disable the second respondent from blacklisting the delinquent bidder if it is otherwise justified. Such power is inherent in every person legally capable of entering into contracts. Well, I don't think this proposition can
That
be
is
done. That's the
based on very simple
well,
principle.
diplomatist.
That
Thank
Yes.
you, Ms. Mishra.
yes, Monday orders. तेरा स्क्रीन पीछे से साफ करवा दो, कोशिश करेगा. Not effect, it's formal, but orders.
For orders, item number 20.
In first case, my lord, there is 11 days delay.
Ram reporter says 22 days.
What happened with the government of Odisha? I
I find it so.
So we are condoning? Delay we can we condone? Should we?
In the first case, 20 days.
Huh? All right. Okay.
The reason stated in the idea and considering the period of delay in filing the resolution. I is according to the law.
22 days.
First one is 22 days, yes.
In second case, 330 days delay. But if my learned friend will agree, plus this is the matter regarding that rehabilitation matter, plus you can dispose of this matter like my lord's order. If he agrees, my lord. Yes.
We can condone the delay and dispose it off.
You are the counsel. No.
Yes.
You are the counsel also in that case. Okay. So State of Orissa versus Pravat Kumar Sahu.
All right.
No, one. Both the cases can be
Yes, yes.
First case also, Mr. Saman?
Yes, no.
In
First
both the
case
cases,
also.
he appearing.
Same.
Alright. No, same dispute.
Same dispute, same.
Realization upon.
Item 21.
Lordship, in item number 21, There is a delay of 124 days in filing of the appeal. In item number 22 also, your lordship, the similar days delay.
Notice has not been issued.
No, your lordship.
The notice, it is within 1 day, returnable within 4 weeks
Limitation.
in the matter of limitation. First one is IA 5572 of 2024. Second one is IA 5573 of 2024. Period of delay is Mr. Sahu, period of delay
124 days, your lordship, in both the appeal.
no 90 stamp reporters have shown 97 days. First allegation is 97 days. Second one is
Just
97 days. Same. No.
In both the matters, I can receive notice for office party.
State is the proper.
Opposite party number?
2.
2. Respondent 1 is the private opposite
Yes,
party.
Your lordship.
We will accept 2 will accept first.
Item 23.
56 date till.
dismissed. Yes, who is for the other side?
You also not, you are not there for the appellant. Which case are
I
you?
was there, lordship. I was there.
Here are you there for the appellant?
Here, lordship, by power, but I was arguing for the petitioner.
Yeah.
Lordship, here also, my friend is it, lordship.
You are arguing for your friend.
Lordship.
Alright. So Chief Manager State Bank of India is notice has to go. So there's only one respondent or 3?
One, only branch, State Bank.
Yes.
Item 24.
So he is Mr. Biswas, your
Lordship.
friend,
Lordship.
on behalf of Mr. Kumar Biswas.
20.
24, lordship, in fact, it has come for orders because I am the petitioner here. They filed a miscase for vacation of interim order. But so they have filed their counter, but I have not filed my rejoinder. Let it fix any other day, any day, lordship, so that it can be concluded, lordship. Because there is interim
No,
order. they
there
have
is no
come-
question of conclusion. He filed an IA when? When was the interim order passed?
Interim order, lordship,
13/3/2024.
13/3/2024.
Yes.
Was it ex parte?
and 27/3, lordship, they appear.
Just a minute. What is, was it ex parte?
Lordship, definitely because they are not there.
All right.
Lordship,
Yeah, just
lordship.
verify.
So when did he apply for vacating?
In this case, I have filed 23/7/2024 millers.
23,
23/7/2024.
23,
7 millers. 23rd July
When did
2024.
you appear?
Yes.
Nine 5/2024.
And thereafter I filed counter affidavit and then will come to Rakesh Nair's.
Along with the counter, you filed that.
Yes, I have already filed counter.
Constitution of India.
So have you examined this article 26(3)?
The lordship, I will examine, lordship.
Where is the question of examination? We all,
Automatic.
the constitution.
But lordship, In usual practice, Lordship, it only vacates Lordship, that is our.
The caution, the Constitution guides us.
That's true, Lordship, but
So there is no requirement of passing any order for vacating the order of stay.
that remains.
In fact, you were required to make an application for
Extension of it.
no question of extension for
Staying and praying, whatever. Because
No,
the
for-
files, it's done.
for,
Because Lordship,
for a fresh interim order. So in the meanwhile, this we can take note of and dispose of his application.
let it be Lordship, next week Lordship, on merit it can be disposed of Lordship.
Merit we will decide, but this application will have to be disposed of now.
But Lordship, usual Lordship gives us chance to Lordship because it is. This
That we will do. That whenever you want, but we shall just record. Because the higher number.
Can it day after tomorrow Lordship on merits Lordship can be.
No, just a minute.
Lordship.
Higher number. What is your number?
Balat, my I number 9531 of 2024. Flat C.
9531 of 2024. This application has been filed for vacating an interim order dated ex parte interim order dated 13/3/2024. Stop. The interim order was granted while issuing notice to the number 5. Your opposite party number?
5 minutes.
5.
State was their Lordship. But
Opposite.
state was Lordship. This is interim order against state.
No, against me because
No,
our contract is our.
No, subsequently. In fact, Lordship, at the relevant state was opposite party.
We are not doing anything. Let's just see the order and then you have
Let's
just listen to the order.
Lordship.
Okay. It is not in dispute that opposite party number 5 is affected by the said interim order. So stop. You made an application on 23/7/2023. What is the name of opposite party number 5?
Plus the Mola Kumar Moon.
23/7/2023. The top. The said application seeking vacation of the interim order of stay has not been heard by this court. 23/7/2024 or 3?
24 minutes.
24. Article 226 bracketed 3 of the Constitution reads thus. What's up? Next. Mr. Dalai and counsel appearing on behalf of the petitioner states that the said interim order was not passed against the opposite party number 5. Okay, top. Opposite number 5. Rather, the same was passed against the state opposite parties who have not filed any application for vacating the interim order of stay. So when do you want? Whenever.
Lordship, please, any date. I'm ready, Lordship.
Subsequent.
There will be conditions of the order must have been passed by the party. It makes an application to be and furnishes a copy of
Fix the date, my 3 minutes. Lakshmi, I 3 minutes of fix of a date, because here the work is our entire stop.
Work is? List this matter. Constituting joint submission advance, so joint prayer, joint request made by land council for the parties. Let the matter be listed soon after holidays. 22nd October. Yes. Over.
Actually, 23rd, let's say, not Tuesday, let's say. 23rd.
23rd, it may be difficult.
24th, let's say. 24th.
Only he can accommodate you.
Great.
Item number 1.
In this case, I am the respondent. I got some time to file counter in this case. I have already sought for information instruction. After receiving the instruction, I have to file counter.
Counter in writ appeal, why?
My lord, I have sought for some instruction because actually whether the land and single judge was the advocate in the previous case or not, I have to know that. I don't know. And whether the status order and whether the stay order has been supplied to the CEO Basagai or not, it is not with me. So I have sought for some instruction. Let it come after vacation, I'll counter and I'll ask.
So you are challenging this order 10/3/2023.
Yes, this order has been arranged. The contention was that while the stay order is in operation, the order has been passed. So my humble submission is that I want to know whether actually the stay order has been received by the CEO Basagai or not.
So knowing is not material. We are not here to enter into that. If some interim order has been violated, you can file contempt application.
My lord, I don't know whether I sought for instruction to that effect.
What instruction? Where is the illegality in the order? What part of the order is illegal which you are challenging? Yes.
No. There is an interim order passed by this honorable court.
So
directing the CEO not to proceed further with the revision case number 263.
Had you filed requisites?
Well,
Had you filed requisites for service of notice on the opposite party?
yes. Notice is sufficient. There was, and the opposite party was appeared in that case.
This case.
Check last time. No, first I was thinking that this thing is being done, but I think- Comment. Okay. Is it you that is? WPC.
So whether the order of Tahsildar is
4182.
appellable? Whether this order of consolidation officer is
Yes,
can be
yes, appellable.
challenge that on that ground also. That despite interim order, the order has been passed.
The fact is not like that. So while the stay order was operating and directing the CEO not to proceed further, he has finalized the matter, violating the order of the honorable court. And the honorable single judge said that as the CEO has passed the order, then there is nothing to decide here. The matter is in progress.
The present writ appeal. Present writ appeal.
The CEO, if the CEO violates the order of the honorable court and pass the order, and if the honorable court is helpless, then
How do you think that we are helpless?
Matter was infructuous. That was decided.
Matter was infructuous. Then why are you not asserting? Can we cause the order of the consolidation officer? in the present proceeding. You can assail that. And you are not here to make an observation that the court is helpless.
No. There was an order. The CO has violated
Please remain within your limits. The court is helpless. We shall impose cost. The appellant has put to challenge an order dated 10/3/2023 passed by a learned single judge of this court in WPC number 14182 of 2010. First off, the petitioner, the appellant, through the said writ application, had assailed an order dated 22/3/2010 passed by the Commissioner, Commissioner Consolidation and Settlement Cuttack in revision case number 263 of 2008, whereby he had remitted the matter back to the consolidation officer Marsha Gai for adjudication under Section 11 of OCH and PFL Act 1972. First off, it was the plea of the appellant before the learned single judge that the said order of the consolidation officer was passed despite an interim order passed by this court on 29/2010 in miscellaneous case number 13378 of 2010. First off, learned single judge, after having noticed that as consolidation officer had already passed an order, the petitioner, the appellant, could work out his remedy in accordance with law to assail the order of the consolidation officer. First off. Next, learned counsel appearing on behalf of the appellant. Appellant has submitted that the learned single judge ought to have interfered with the order of the consolidation officer on the sole ground that he passed the order despite an interim order passed by this court. First off. Next, it appears to the court that the petitioners, the appellant, somehow or the other, intends to linger disposal of the matter, which is pending for more than a decade. First off, instead of putting to challenge the order of the consolidation officer on merits before appropriate authority, he filed the writ petition on a technical plea that there was an interim order. First off, interim order passed in 2010. First off, learned single judge, in our opinion, has rightly held the writ application to be infructuous, as the consolidation officer had already passed an order giving the petitioner a liberty to pursue his remedy before appropriate forum. Stop. The forum, the writ appeal is accordingly dismissed. The appellant shall be at liberty to pursue his remedy before appropriate forum in accordance with law.
Item number 3.
May I please answer? just to remind your lordships of the facts of this case. Your lordships have heard it once, so just reminding your lordships and refreshing. But there are two hotels side by side at Puri, in the near the sea bridge. One of the hotels of 48 bed is mine. One of the hotel is mine. The other hotel is of the respondent number 3 and 4. They were the original owners of that land. They sold it in 93 by the register sold it, from whom I had purchased in 2008. Some permissions are there. The issue before what happened, it started, if you also remember, it started with that some garbage was put from my side to their side, for which they initiated a complaint before the Human Rights Commission. Lord, of course, I keep it aside that how the human rights will come to play in this, but Human Rights Commission, because the Human Rights Commission directed, both the collector, the pollution board, all were activated, and they stopped the functional of my hotel. I came up before the Honorable Single Judge. It's a writ appeal. I came up before the Honorable Single Judge. The Honorable Single Judge first initially directed that let the parties sit. But this is relevant for which I'm saying so. Let the parties sit. That means the contesting parties sit and sort out the issues in presence of the pollution board. There was an order, but it didn't work out. But after it didn't work out, that Honorable Single Judge has dismissed my writ. But while dismissing the writ, he has made such an observation that I'll never get it again on my land goes, that he says that my rights in the title in the property is void because it is a customer land. But I'll just take your lordships now for a limited aspect. But I have filed an affidavit because in the good sense prevailed on all the parties, and they sat down, and the 3 and 4 contesting for lordships is the flag E. But an affidavit is there for lordships. F. For lordships, be pleased to see flag F. That affidavit. Flag F, my lord. You have extra copy. Have you also got it? I'll give some extra. Yes. Yes. But this was, if you also are just referring, Lord, this matter is taken up through hybrid arrangement. This was the Honorable Single Judge order. If you also says that para 3, both the proprietors of hotel and intervener, para 4, in view of our submission, Learned Council of External Officers, State Council shall intimate about the appointment and responsible officer to present time of sitting. According to the parties, the to intimate date and time, and the second sit and sort out. It didn't happen, for it was dismissed, my lord. And that was also a ground. My lord, I have said in this that we had approached respondent number 3 and 4. My lord, if you also see page 3, A, B, C, D, what we have proposed, my lord, not running the hotel per se at now. Kindly see, sir, page 3, A, B, C, D. Page 3. The respondent number 3 to resolve the dispute and redress the grievance involved in the case, to restore and maintain cordial neighboring relations with them, settle the interest in this context, the applicant undertakes. Applicant is me, to do the following. But A, I shall close that the objections which they have. Close the 3 numbers of windows and skylights. That ensure not to drop any garbage in the premises of to, if Lords get it. Shall make necessary arrangements to ensure sewage, etc. Applicant had discussed with respondent and agreed to do efforts and will not cause any inconvenience. The applicant wholly undertakes to close all openings, etc. of the Swarga. That's my hotel. Undertakes. But here also I have undertaken that the since has sealed.
What is the name of your hotel?
Hotel is Swarga, my lord.
Very risky. Very risky to go.
And the neighbor is, I don't know which is, which is that the neighbor is Swapnapuri. Swapnapuri, my lord, as the lordship knows, Swapna means the tree.
Yes.
Yes.
So which hotel should be entered first?
Yes.
My lord, I'm just a prayer at this stage. The matter will come up after vacation. Is that since the state pollution has sealed, my lord, that's they are following. My lord, it is a 48 bed, and once it is sealed from 38, that means 1 month is already over. It's sealed. And once the room is sealed for 1 month in a Puri side, what happens to the hotel? You will also know. Everything will be destroyed, termite. I have undertaken not to start the hotel, but let it be open. I will execute this and come back to your lordships. That's what I prayed, my lord. Therefore, want of consent not being obtained, that after state pollution may consider to open the seal. I have just told the appellant. Also undertakes that the opening of the seal efforts at work will be completed, but the hotel will not be operative. It will not be operative as a hotel. It will not be operative at a hotel till your lordships allows me to do so. For the time being, my lord, let it, because as such, not this sealing is, they can direct me to stop construction, not sealing it as a whole entire 48 million. Your lordship knows what will happen inside that. And in fact, that itself will be a danger for the society. Because what will happen inside, let's say it will happen, foul will emit or whatever. So what I propose is.
Who is for the board?
Because lordships.
Who is for the board?
Yes.
We have which is running the hotel without any consent.
He was running.
Yes.
Now it is sealed.
No, yes, he was running the hotel without any consent. That's why we have.
So for the limited purpose of.
But I am not taking your lordship to merits. Consent, these are all deemed consent. Lord, as the lordship know, there are many statutes, these are deemed consent. If you apply, they don't say anything, deemed to be. But I'm not on merits at all now. Because number one, I had a deemed consent.
We should be on merits.
Yes.
At least on this aspect that you had deemed consent.
Yes, sir. Sir,
Otherwise,
yes, not deemed consent because it is sealing. But in any case, my lord, what I am humbly submitting, the pollution board has a right to stop activities, but not a right to seal the activities. That's what is the basic, Lord. They have the right to say that, let's say, Lord, for the timing that I don't have a consent. Then
where is that?
They have no right to seal the activities, and your lordship says deeming consent. Deeming consent.
No, forget deeming. Where do you have that right to seal? The hotel has been sealed.
Since he was running the hotel without any consent to establish or operate. And the Honorable Court has already directed to see that the proper action is taken by the board. See the paragraph.
Mr. The board will not cannot take any action which is not within its jurisdiction. All right. If there is a building, and according to you, the very existence of the building violates any provision of under the Act, the matter is different. But because of certain activities in the building, the pollution is being caused, then you can stop the building, stop such activities. But how can you seal? Under which provision? You can seal that. Have you sealed physically? You have done it.
Yes.
After the collector has done.
Why is
After
order?
the direction of the
Pollution.
Where is where is that power?
43A speaks that. 43, so what, right? 33A. 33A. Yeah.
33A of water prevention and control of pollution. Which provision you are saying?
33A.
33.
A.
Capital A, sir. Capital.
Yes.
Notwithstanding anything contained in any other law, but subject to the provision of this Act and to any directions that the central government may give in this behalf, by board may, in the exercise of power and performance of the function under this Act, issue any direction in writing to any person, officer, or authority, and such persons, officer, or authority shall be bound to comply with such directions. For the avoidance of doubts, it is hereby declared that the power to issue direction under this section includes the power to direct the closure, prohibition, regulation,
So what else?
any industry, stoppage or regulation of supply of electricity, water,
Yes.
or any other services.
How can you seal?
Well, since closure has already been done and he was operating.
No, not
that's
after
why-
that. Not after that.
Closure means closure of a business.
Closure we have done.
Closure, prohibition, regulation of any industry,
Yes, ma'am.
operation or process. How can you seal the building?
Since he was operating, that's why we see. He was operating despite the direction of the closure.
If he was operating, then what could you have done? Whether there is any, did you start any action? Whether there is any penal provision, offences, penalty.
Yes, ma'am. Penalty is not there. Closure direction is there. After closure.
Penalty is there, Mr. Counsel.
Penalty now, the penalty, NGT also, impose penalty. Under section 2. 16 euros. Board cannot give penalty. NGT will not. The power to people. Impose penalty. On the police polluted.
No, but you should have approached the Green Tribunal. Why
Yes,
did you?
my lord.
I'll come to that.
33
But I'll come to that.
33 is the.
Green Tribunal also I am aware, not I'll tell your
33 is the
lordship.
provision.
My objection is the order of the High Court, Lord. Unless the order of the High Court stands, that will go or not, that will lordship should
No,
decide.
that we understand, but why?
If
did
the
you
order of the High Court is there, nothing will happen, my lord, because everybody is bound by the order of the High Court.
No,
Order High
who
Court has
approached
already
the-
directed.
Oh, who approached the High Court?
Lord, I approach the High Court.
Again,
I approach the High Court.
that thing.
I approach the High Court, sir. So what happened, my lord? I approached the High Court. I got I approached the sequel. He, on the direction of human rights, passes an order that to closure. I come to the High Court, and the Honorable High Court, at a first instance, gives me an interim protection. Well, my running was not in violation of any order, but in running of the High Court interim. At that stage, the High Court said that you both sort it out, sit together, sort it out. That you are also seeing. Thereafter, my lord,
All right, where is the order of the board?
the board order is in consequence of the High Court order.
Kindly see annexure 9, 10, 11 of the writ
No,
petition.
yeah, just
That was show cause notice was given.
I was show
You
cause notice.
comply all the requirements because
Please
you would like to get
allow
a
him.
consent.
Please allow him.
Yes, sir. So what happened, my lord, after the High Court order, in view of the High Court order, at page 43, he passed an order without any further notice. It's because of the High Court order. So unless the High Court order says, not in the reason our High Court order. Kindly see, sir, page 43. Page 43 is the
43 of the writ petition.
There's a writ appeal. sir.
Writ appeal.
Writ appeal.
Yes, sir. This is consequential. The initial order, my lord, for which I came to the High Court, if your lordship would like to see, is at
No, this is consequential to
this
the
is
High Court
consequential
order.
to the High Court. Consequential to the High Court, my lord. Initial, sir, was at page 22. Page 22. Your lordship, page 22. This is consequential because of High Court order. But my entire case is the challenge is the Honorable High Court's single judge order saying that I have no rights. If that, unless that order goes, my lord, nowhere I will get any relief, my lord. Nowhere. Because of the Honorable Judge's order, single judge's order. My lord, at the present, sir, I would only, as your lordship says, whether the High Court order will survive or not survive of the Honorable Single Judge, that's a matter for your lordship's consideration. Because according to me, that order is incorrect. That order is incorrect because he says that my cell right is void. I had shown to your lordship a judgment of the High Court saying that it is not void. I have got a transferable and heritable right. But I didn't take you to lordship the entire gamut of the case because of the fact that at this stage I'm only wanting to open up the shop to that because this your lordship sees at page 44. Page 44, if your lordship sees, this order was a consequence of the High Court order. Page 44 was the date of hearing the Honorable High Court directed both the proprietor of hotel to resolve the issue applicable. I am reading from 44. In this regard, communicated both the petitioner hotel take necessary steps to resolve the issue. Whereas in the meantime, Honorable High Court is going.
So where is the sealing part?
That if lordship says that this stoppage, intimate stoppage, and they go to sealing.
Who?
They.
So you should have grievance against that.
No, this is the order, my lord.
There is no order of sealing.
No, this is the order, your lordship directed. Your lordship said revoke the consent operate gantry unit, direct to stop operation immediate effect forthwith till compliance. Lordship get at page 45.
Yes, yes.
You are also directed to intimate the date of stoppage of operation of unit forthwith, failing which will presume that everything. That's what they said. And
so where is who sealed?
They said
who?
Pollution.
Where have you said?
No, that's pollution seal, my lord. I have said.
No, where have you seen?
Writ appeal have you stated?
Yes, writ appeal I could attach it.
From that they have only said stop operation.
But they have sealed.
Not only that,
Yes, sir.
we are putting this question
Sir.
specifically because you want us to pass an order for unsealing the hotel.
Yes. So they.
So unless the hotel has been sealed, where is the question of any direction for unsealing?
That's true, but it's an admitted fact and sealed by them, the statement.
Why? How can we know?
Yes.
It may be between your personal knowledge, his personal knowledge.
Yes.
So are you admitting that you have sealed?
Yes. That's the affidavit I've sealed. And the affidavit I've stated below.
It's not sealing, it is closure. It is closure.
So by closer to the locket and.
That means because it-
Mr.
The difference.
Mr. Nanda was making a submission that because the hotel has been sealed and some maintenance, this thing, work is required to be done.
Two reasons I'm asking. To resolve the inter se issues.
Inter se issue is different.
That because of that only the inter se emanated.
Inter se issue is different. You wanted for the present a particular interim order that should be unsealed so that the
Things to be taken.
hotel is.
That's all. And without running. Without running. But I'll give an undertaking, Lord, that it will not run.
No, but where is that? Why should we pass an order?
Sir. Yes, sealing. So far as sealing is concerned, it's part of that affidavit, of course.
Where is that?
That affidavit which I have not seen yet. These affidavits, sir, which you read. That para 4, sir. Para 4. Para 4.
He may not be knowing.
The para 4, that's the affidavit.
Para 4 of the affidavit.
Sir.
All.
That the efforts of circumstance state pollution control may consider open the seal of Hotel Sorgo appellant also not that after opening of seal, the efforts at work will through complete hotel.
No, when was that? Which paragraph?
Sir, I'm reading para 4 of the affidavit.
All right, we will hear you tomorrow.
Sir.
You file an affidavit stating the date when the
Yes, when it was sealed.
hotel was sealed and by whom.
I will do so.
Under which authority? And you will have to say under which authority.
I will do so, sir.
Where have you said?
Sir, I have stated para 4 of the affidavit. The state pollution may consider open the seal of Hotel Sorgo.
An affidavit has been filed on behalf of the
let it be
appellant, which gives an impression that the appellant's hotel at which place?
It's at Puri.
Puri has been sealed by the authority.
Pollution board for lack of.
Full stop. We do not find on record any order whereby the hotel Swarga was directed to be sealed by any authority, including State Pollution Control Board. Full stop. List this matter tomorrow within first 5 cases so as to enable learned counsel appealing on behalf of the appellant to file an affidavit indicating the date when the hotel was sealed and by which authority.
Sir.
The date / manner of sealing and the authority who caused the sealing.
Manner of sealing also.
Yes,
they
yes.
put a law.
I'll fight.
No.
Sir,
you tell them that there is no order and there is no power. So if
I will file your lordship.
you don't have to do anything. If tomorrow we reach a conclusion that that has been sealed and on that day seal was put and you did not have any authority and there was no order given to the officials, then we will pass appropriate orders. All right.
Sir. So these two because tomorrow is holiday. Second.
All right. Third.
Yes.
Third. Sir. I'm not there after that.
I have difficulty.
No, that's there.
Third.
Me and pollution. Now it's between me and pollution. You are an intervener.
Third.
Me and pollution.
You have resolved.
Yeah. Me and pollution.
Both of you have resolved.
We have resolved, but he has given the affidavit. But I have to give my consent also. Any application to that effect.
All right, that we will remember. Even if you are not here, we will remember that you had given consent on third.
Grateful, sir.
Item 4.
Item 4, my lord, I prefer no adjournment, my lord, prepare short note.
Right?
Item 4, my lord. So prepare short note, my lord.
Notes.
I've already informed to my learned senior also.
What is the dispute about?
A dispute about regarding termination of contract, imposition of penalty. Now they proceeding to blacklisting, my lord. I have to make some points, my lord.
So these are two different aspects, Mr. Counsel.
Yes, my lord.
But if you can challenge the order of blacklisting.
No, blacklisting not yet done.
So therefore, why are you?
No, my lord. This is different, not related to blacklisting, my lord.
Then
I prefer my lord short adjournment.
Amendment, what had you filed amendment for?
Amendments, even 20% proceed one, they have initiated a proceeding by amendment, me to impose 20% penalty for not doing of the remaining balance work. That amendment.
And you've given an affidavit that you're willing to complete it within 6 months.
6 months.
So that is still open, or you've given tender?
and then why should we decide such dispute?
Because it is given to somebody, I think, no.
No, not as winner. The court has direct take instruction.
No. If I remember correctly, were you saying that you are willing to complete within 6 months, but they have floated a tender saying
8 months.
giving 8 months?
Yes. And the imposition of penalty, my lord. No, tomorrow. The lordships day after tomorrow.
As requested on behalf of the.
Next week, my lord, because some instruction day after tomorrow, some personal difficulty. I have to go. Yesterday is holiday, my lord, tomorrow is.
Requested on behalf of the petitioner, list this matter on Monday. The
Yes, sir.
first 5 cases. Yes.
Obliged.
Item 5.
Please, your lordship. Lord, this is a second
Well,
confinement.
in item 5, already process has been made for release of his salary. Let me give some, because there is a delay in complying the order. I have talked with, it will be released within 1 week or 2 weeks. Let me give 2 weeks time. In the meantime,
As
that order will be
requested on
complied.
behalf of the contenders, list this matter on 2 weeks. No stop. It is made clear that the court will be constrained to initiate contempt proceeding if by the next date this court's order, violation of which has been alleged, is not fully
Yes.
complied with.
But
Item number 6.
Item number 6, my lord. I am to the respondent, I pay 10 days time to file an affidavit in view of the direction of the Sonal Court.
Yes, what is this matter?
I file an affidavit, my lord, director of 11th September,
We had directed.
my lord, 11th September, my lord. So we have already, my lord, applied and some information has been received and some information they are awaiting. So I pay, my lord, 10 days to file an affidavit to bring that record in.
So you are respond number 1.
My lord.
11/9/2024, you had taken time
My lord, my lord.
to seek instructions whether any persons above him in the merit list
Were not appointed,
was not engaged.
not with me, my lord.
Yes, we will not. We will not adjourn it.
10 days time.
No
My lord, we
question.
have already,
No question. You are unnecessarily delaying it.
my lord, they have already applied, my lord.
Last time I remember,
My lord.
I vividly remember that last time you were saying that you had filed an affidavit
My lord,
stating that these were you did not read not. So your list was engaged as primary school teachers.
that affidavit was, my lord, wrongly filed because that was filed.
Wrongly filed, and then you are not filing because they are avoiding.
No,
Your case is the entire process of selection was set aside on the ground that appointments were made on pick and choose basis. All right. Some below in the merit list they were appointed, above in the merit list they were not appointed. In that background, we had put a question, we had asked you to file an affidavit whether someone above you was not appointed. So if he was not appointed, then how can you claim? And that discloses the kind of irregularity. Why this?
At least 3 days, my lord, because some information, 3 days time.
What information?
My information is subject to my lord's access. My information, my lord, they applied that intimation was given to the persons, those are above to the petitioner's, my lord, petitioner position. They did not choose to join. Accordingly, petitioner position come for zone of consideration. That is my lord, because petitioner position was 139, my lord.
Then you will have to pay cost, even 500. We'll grant you.
My lord, as my
Learned counsel appearing on behalf of the petitioner again seeks adjournment to comply with this court's order dated 11/9/2024. Was opted this case on Monday, retaining its position so as to enable him to file the affidavit subject to payment of cost of ₹500 to be deposited in the account of SS Jovial Welfare.
I'm paying cost, my lord.
Tuesday.
Tuesday, my lord.
Item number 7.
To my submissions that the matter comes before division bench, my lord put a question under which provision it comes under division bench. Under chapter 3, rule 10 of Orissa High Court rules, the roster arrangement is
You are appearing in WA 340.
Pardon?
You are appearing in writ appeal 340.
340, bad.
Yes. So what is the ground of your challenge?
My past submission is this matter is to be adjudicated by a division bench as per roster arrangement.
Yes.
Chapter 3, Rule 10, allocation of business
Yes.
allocation of business is made under chapter 3, Rule 10. Which matters are to be heard by the single bench and which matters are to be heard by the division bench.
Yes.
And are filed the composition of benches wherein the OEA matter comes before the division bench number 3.
No. Forget the roster. Are you referring to rule?
Rules.
So refer to the rules.
So rules 10 I have filed. Rule 10. Chapter 3, Rule 10.
Yes.
Under which the bench compositions are made. And accordingly, I have also filed the bench composition wherein the Orissa state abolition matter is allotted to bench number 3.
The Odisha state abolition matter is not in the assignment because the Chief Justice has decided. It is because the rules provide.
Rules provide.
So let us see the rules first. Then we shall see the assignment.
Rule 10 I have filed.
All right. Please sit.
Chapter
Please
3.
sit down. Let us examine.
Chapter 3, Rule 10.
Please sit down. Let us examine. Please sit, Mr. Counsel. Please sit. Not there in the.
No, but there is some.
No. There must be somewhere. Writ petition or something.
It's only rule. Hello, can I go? Samantra, I may be mistaken, but I remember some notice or appendix regarding the cases which will be listed before
Appropriate bench judgments. In fact, as per the roster minutes published by Lordship, servant settlements honorable single
I
judgment.
know. State abolition before the division bench, that has been always the case.
Land
Oh,
acquisition, OEA,
Mr. We want to know whether under the rules, allocation of writ matters have been provided or not. Under the rules, not under the
roster minutes, I understand.
Specifically under the rules, I remember.
because the rules which he is referring to do not refer
Contain
to
that specifically.
Yes. I'll find out
There is
which are, but there must be there on the rules.
Just by allocation of low roster,
Without
normally it should not be there.
being backed by the powers under the rules, it cannot be done, Milord. I'll find out, Milord, sir.
Decided that this may be
But
there.
there it is also
Oh, criminal matter.
Had you pointed it out to the learned single judge that this is a division bench matter?
The specific subject is not mentioned in the rules. But as per
Review
rule
was
of
filed, just make one thing, Honorable Single Judge not passed the order. Thereafter, a writ appeal was preferred, Milors, and the writ appeal was withdrawn, Milors, without that he will avail a subsequent remedy. So he filed a review, Milors, and the review it was stated that specifically it has been allocated to the Honorable Single Judge by the order of the Honorable Chief Justice, Milors. That is there also in the review petition, Milors. So now thereafter he has assailed that, saying that it's a division bench assignment, Milors.
While withdrawing the writ appeal, earlier filed,
That is what he has said.
my lord,
Let us examine, let us understand and pass order. You are not required to make any submission.
I was given liberty to file writ appeal after the disposal of the review petition.
Yes, that is it.
Monday.
And that is annexure C.
Yes, we will try.
Liberty was given and accordingly I have filed the writ appeal. Present writ appeal.
Who granted you liberty?
Milord?
Communication is impossible. Yes, Monday.
Item number 8.
Monday.
Indicatory.
In
7 तारीख
There is no such then like it's very easy for me to react.
Eight, my lord, before my learned friend starts, he served a copy of affidavit just now. May I pray this matter can be taken up next week? Just
Have you served any affidavit?
Yes,
Yes. Let him consider.
But this is regarding what?
This is regarding similarly situated persons have got the relief and I have given the list.
No, it is before a division bench. That's why I'm asking. It has to be a service
Yes.
matter.
Yes, service with that virus of the resolution is under challenge.
Virus of a resolution.
Yes.
Is that statutory?
That is not statutory. That was issued under Article 162 of the Constitution.
All right, we will see later. It is stated by Mr. Kotial and AGA that an affidavit has been filed on behalf of the petitioner today itself, which he needs to consider. Stop. As requested, list this matter on 2 weeks. Yes.
Item number 9.
Please, your lordship. Not the annexure one, which is the gadget notification. So far as the charges to be paid by the residents of a particular not apartment, which was earlier, it was, if your lordship should see page 20. Page 20.
This is WPC 16856. Oh.
Yes, ma'am.
Yes, page 20. Annexure 1.
Yes.
Yes.
The lordships may come to third like second subpara after the first one, and whereas subsection 1 of section 18. If your lordships can have it.
Yes.
Of the said act provides that common profits shall be distributed among and the common expenses shall be charged equally on the apartment owners irrespective of the undivided interest in the common areas and facilities. So irrespective whether it is like somebody has taken a 1 BHK or a 2 BHK or 3 BHK, so far the common facilities are concerned, like a lift or the passage or the lighting, it will be equally distributed because the usage is the same. It is not that somebody who lives in a 4 BHK or a 3 BHK, he uses the lift or the light more than somebody who doesn't. Now that has been changed. If your lordships would come to the second page, 21. That has been now been changed from equally to proportionally. Like for a swimming pool or the passage or the lift, the usage charges are to be divided proportionally as per the...
Yes, so what is wrong in it?
No, my lord, the usage is the same. Like I may live in a 3 BHK house, I don't use the lift more than what a single, like 1 BHK owner stays. So for the maintenance is concerned is a different issue, my lords.
Number of occupants may be more, so probably that is the reasoning.
No, that they have not mentioned also. They have simply said, so far as the area is concerned.
So what are they asking you to do?
Well, the same. The earlier what was there, if your lordships would see that page 20 I read out, it was equal for all the flat owners. Now they have said it will be proportionally for the common usage expenses.
See, there is difference between the profit. The profit is to be equal. You are required to pay more because you occupy more area. So if a person having 1 bedroom apartment shall be entitled to the same profits. But when it comes to payment or maintenance or whatever.
No, it is not for the maintenance.
Then what?
My lord, that is common expenses. Maintenance is the next, which was earlier also proportionally, which we don't object to. If your lordships would come to the fourth one, for the association to distribute the common profits and charge for maintenance of common area and facilities proportionately. That is already there. That we don't object to.
No, you are referring to which clause?
My lord, clause in the in the fourth word of the before clause 1. If your lordships would come to fourth subpara from the top.
Page,
my lord, 20, annexure 1, which was
20 I have seen.
The gadget notification which is there.
Yes, page 20 I have seen, but after that.
My lord, then 21.
21 is what? It's a minute of governing body.
No, my lord, this is part of the... My lord, there's 2 lines. I don't know if it has been missed out in your lordship's brief. Then I'll, my lord...
2 lines where?
In page 21, your lordship.
Page 21 is
21, yes. In Odisha apartment, so and so.
Yes. For the word equally, the word proportionally shall be substituted.
Where is that section? Which page? Have you quoted it?
My lord, I'll just...
Why this? This is a ship apartment. Huh? Odisha Apartment Ownership Act. What have you stated in paragraph 3? Odisha Ownership Apartment Act.
Yes, ma'am.
That is Ownership Apartment Act. Or
Odisha Apartment Ownership and Management Act
exactly.
23.
It can be apartment ownership, not ownership apartment. Check paragraph 3.
I'm sorry.
Odisha apartment ownership.
No.
And I'm sorry, my lord. It has been.
Yes, all right. There. Odisha Apartment Ownership Act, 1982.
Section 18.
Yes, yes.
Correct.
Common profits and expenses.
Yes.
Absolutely.
Yeah.
Act, I believe, my lord. The Act 23 Act. Odisha Act 8 of 23.
23 Act. Not there only? Last one. So Ownership and Management Act. That one.
My lord, the Odisha Apartment Ownership and Management Act 23. Act 8 of 23. Odisha Act 8 of 23.
It's very reasonable. Very reasonable.
My lord, the expenses which are the common facilities. My lord, if somebody was paying, let us say, he has a 3 BHK apartment. So far as the lift is concerned, so what he uses is the same by a 1 BHK even in the same floor.
Now suppose your association decides to sell off a flat.
No, association cannot, my lord.
All right.
It is individual owners here.
All right. All right. If the association has, say, market complex that they can have, and the association can derive benefits also, that benefit may be such that maybe beyond, maintenance or anything, can be profit of the association to be distributed amongst the owners. So even that shall be proportionate. So if you have a bigger apartment,
as on date, so far as the Orissa Act is concerned and the permissibility of having the financial or
We
the
do not
commercial establishments, that is not permissible. They cannot have a commercial establishment inside the apartments. They can have it outside, but that will not be part of the owners association. That will be of the builders.
But they must be paying the electricity.
No,
No, what you are saying, that why you challenging that 1 bedroom, 3 bedroom? Why should it be the
No,
same?
my lord, I'm saying 1, 2, 3, whatever, irrespective of the same, the passage. There's a lighting of the passage.
Okay.
Or there is an open lighting of the area, park,
Yes.
or a swimming pool, let's say,
Yes.
or a lift, which are common usage.
Lift is different.
Well, lift
Number of
is,
times it goes up and down.
no, maybe
Electricity.
well, it is not that I stay in a 3 BHK, I will use it more, or a 1 BHK. So,
More number of people will be staying.
so if that would have been the criteria.
We are not required to go into all those nitty-gritties. Not only that, common. Suppose in 1 bedroom flat there are 5 people staying, and in 8 bedroom apartment there is only 1 person. So can you say that he should pay more because there are 5 persons and in this?
No,
there
I'm
is
not
one?
saying that. My lord, I am not asking for that. Thing is all should pay equal.
All
I'm
right.
not on the numbers.
All right. We have challenged this provision.
This provision.
The police section 18 bracketed 1 of Orissa Apartment bracketed Ownership and Management Act 2023.
I don't challenge
Before-
the act, my lords. The subsequent amendment
Yes.
in 24, which has
Yes.
been brought out.
Before its amendment by amendment with effect from 9/2/2024, read as under 18(1) Code. By the Orissa Apartment bracketed Ownership Management what is the name of the act? Amendment
I just
comma,
on judgment of the Bombay High
removal
Court on the
of-
same lines.
the removal of difficulties. Second order, what is the? Let me see.
On the
This is not
similar
an
lines.
amendment. You can't do. This is not an amendment. No. This has been done in exercise of power under section 37
Difficulties.
under section 37. This is not an amendment.
What is this judgment you given?
Lord, this is a High Court of Bombay judgment. That is WPC number 1948 of 97. There, my lord, it said that irrespective of the area, the common usage area should be charged equally. What I am, my lord, pleading before your lordships. And there are 2 judgments, in fact, both of the Bombay High Court. If your lordships would see para 8 and 9 of that judgment. Para 9, your lordships may.
So which you have given us 2? Which
2
one?
judgment. The first one is that 97 decided on
So
37.
that is para 8.
Para 9, your lordships may say.
No, but in those cases there was no such provision. The society here it is
The
a
rationale,
decision.
my lord, behind that, why they have changed.
This background.
No, my lord, that I'm not getting into that issue. And also in the second judgment, para 5.
So the cases are different. Here it is the policy of the legislative policy. Here
That is why, my lord, the challenge I have made before your lordship, that is why the notification I have challenged. Because the rationale behind is like, my lord, should appeal to the common sense also as well as otherwise. But it should be legal and should be rational as well as be justified. It should not discriminate one against the other.
Yes. The Orissa Apartment Ownership and Management Act 2023. Read as under. Stop. Section 37 of the Act Section 34 of the Act confers upon the state government jurisdiction to make such provision file affidavits. Difficult question.
Not solve my.
See, serve a copy.
I'll serve in the course of the day another copy.
No. This is come to section 34.
34, but removal of doubts.
Removal of doubts. It says
It's not inconsistent.
not inconsistent. So either proportionate can be said to be
Not-
inconsistent or not. So they could have amended, but possibly they could not have exercised that power. That is the question.
That
Please examine.
I'll give a copy in the course of the day, my lords.
Section 34. Section 34. In exercise of power under section 54 of the Act, the state government has issued an order on 9/2/2024 to for incorporating therein, following. Whereby the word equally in section 81 has been substituted, 18 has been substituted by proportionately. So stop. Next, it is they said order dated 9/2/2024 has been put to challenge in the present writ application on the ground that section 34 of the Act can have application if the order sought to be met is not inconsistent with the provisions of the Act.
The existing provision.
By
the existing provisions.
Provision of the Act. So stop. It is the submission of senior counsel that substitution of the word proportionately in place of equally is inconsistent. Substitution of the word proportionately is inconsistent with the statutory mandate under section 18 bracketed 1 of the Act. So stop. Let a copy of the writ petition be served on.
I've already
A copy of the writ petition has been served on learned AGA for the estate. Stop. 8 weeks, file affidavit.
Also, I filed a miscase, but notice they also may respond.
Notice kar dena, accept.
Obliged.
That is a question. Arguable.
Item number 10.
May I please alert? In this instant, writ petition, the petitioner seeks to assail the.
Which item?
10.
Yes.
Seek to assail the order dated 18/7/2023 passed by the opposite party number 3 under Annex 1. That is illegal, my lord. And on the last occasion.
Where is that?
That is page 33 under Annex 1.
30?
33.
Is illegal.
Illegal.
How do you say?
Oh, that is in contravention to the provision of the rules. The petitioner has a mining lease for the period of 5 years, which commenced from 2017 to 2022, my lord. In the lease period, the petitioner apprehends less quantity of ore, filing and modification of mining plan before the appropriate authority. And the mining plan and the modified mining plan is duly approved by the authority.
No, this order has been passed by sub-collector.
Sub-collector.
So why don't you go before some higher authority?
That, my lord, your last occasion, your lordship may be directed to me whether 46 clause 2 will be complied or not, so far as the payment demanded amount. To that effect, my lord, I have filed an additional affidavit. And in the additional affidavit, the statement of accounts, the demanded amount noticed by the opposite party number 4.
You are challenging Annexure 1.
Annexure 1.
Annexure 1, what is wrong when the, let's come to the last paragraph of the order. Last but one. On perusal of so-and-so as well as the case record, neither the applicant has deposited the demand amount. So have you deposited?
Yes. Filing additional affidavit to that effect, my lord. Flag.
What?
The demanded amount. Under annexure demanded amount by notice number 372 of dated 5/2/19, that is under annexure 6 and corresponding to annexure 7A, demanded amount is 1,27 lakhs. I have been paid. Categorically filed a statement of accounts in additional affidavit annexure 12B.
When did you deposit?
Yes, my lord.
When did you deposit?
Deposited in the year 2021, my lord.
No, when did you file your appeal?
Appeal filed, my lord. Appeal filed.
So you had deposited the demand amount?
Yes, my lord.
No,
Oh, he said he has deposited and the ground is.
he's saying I want refund and pay the excess.
My writ application will be prayer that the demanded amount, which is in violation of the rules and paid excess to the petitioners. How
much amount was demanded? What was the amount demanded?
They demanded an amount. Annexure 6. 1. $132 under annexure 6. They demanded an amount of 1,27,18,000 odd amount 908. Okay, that is for the financial year 2019-20, corresponding to 2019-20 financial year.
So previous years you have
Paid.
What is the amount? Where is the amount mentioned? 1,27,18,000.
18,000. That is an excess amount, my lord. Because of there is a modification of mining.
Did you deposit this amount?
Yes, my lord.
When?
Deposited in the year 2021. The amount, including the amount for the financial year 2020-21, that is annexure 7A, page 40.
Where is that? Where is the proof of that you had deposited?
That is the statement of accounts filed annexure 12B. And in additional affidavit.
Additional affidavit.
Affidavit flag A. That is statement of accounts.
Mr. Counsel, where is the proof that you had deposited 1 crore 27 lakh and odd?
My lord, that is the statement of accounts. I have been paid to the direction of the opposite party number 3 to the government treasurer. That is the account statements. I have been paid, my lord, for the financial year 2019-20 on dated 21/1/21 paid 24 lakhs. In this manner, paid 1 crore 58 lakhs for the 1 crore 58 lakhs, including 24% interest 30 lakhs. The demanded amount is 1 crore 27 lakhs.
All right. Where is your memo of appeal, which has been dismissed?
Memo, that is under Annexure 1, my lord.
Annexure 1 is the order.
Order. Appeal, my lord. 1 minute. 149 page, Annexure 9. That is the Toji Mish Appeal number 1 of 2021.
So whether in your memo of appeal, you disclose that you have deposited the amount?
That is, my lord. That is, my lord, page 41. Page 141. Order passed by the sub-collector, page 141. May I read, my lord?
Yes.
As per the settled provision of OMMC Rule 2016, Rule 46, Clause 2, no appeal shall be admitted unless the amount, if any, assessed in accordance with the provisions of these rules as per the orders has been deposited. The appellant is directed to deposit the demanded amount, if any, before the respondent and before appeal before this court afresh for hearing. Thereafter, my lord, the opposite party number 4 issued demand notice corresponding to Annexure 6 and Annexure 7A, and the petitioner has paid accordingly to the demanded amount and filing the appeal afresh.
Let us see.
No, you are saying that you have paid the amount of 1 crore 28,000, 7,000 some odd.
Yes.
But that amount should be 49 lakh something as per the modified mining plan.
I am excess paid. The modification.
That is according to you.
No,
Where do they agree that that is the position?
No, my lord. My lord, what I am trying to submit to your lordship, there is a modification of mining plan. The mining.
Please wait. Don't worry. The petitioner's appeal under Rule 46, bracketed 1, read with 2 of the MMC rules, has been dismissed. Rules being appeal number 1 of 2021 has been dismissed by the sub-collector Balasore in Toji. Miss appeal number, Balasore, by an order dated 8/7/2023 on the ground that the petitioner had not deposited the demand amount noticed by Tahsildar Basta by notice number 372 dated 5/2/2019. And you did not prefer appeal before the collector?
Yes, I prefer appeal before the against my lord, to feeling aggrieved by the impugned letter issued by 372. The petitioner preferred an WPC before this honorable court, and in the WPC, this honorable court directed to prefer an appeal. That is the appeal 1 of 2019.
Where is your appeal?
Appeal 2019, my lord. 101 of 2019. Annexure 7. That is the order of the appeal.
The order we are asking, where is the appeal memo? We annexed it.
The appeal memo 2019 is not annexed, my lord.
All right. Order is annexed.
Thereafter, the petitioner, my lord, as per the order passed by the opposite party number 3.
Mr. Counsel, please understand our difficulty.
Yes,
also.
my lord.
We have not been able to understand anything.
Yes, my lord.
Not even a single.
Yes.
We are trying to understand the basic dispute.
Yes, my lord.
This order has been passed on the ground that you did not prefer an appeal and you did not deposit the amount.
Yes.
Requisite for preferring the appeal. You have not annexed the memo of appeal, which you don't have.
Yes.
Then what is the legality in the order?
Yes, no, my lord. My lord, what I am submitting, my lord, the opposite party number 4 issued the notice dated 372 of dated 5/2/19 and feeling aggrieved, the petitioner preferred a WPC. In the WPC, this honorable court directed to prefer an appeal. Thereafter, the petitioner filed an appeal, that is appeal Toji Mishi appeal number 01 of 19. In the said appeal, this the opposite
01 of 19.
19. In the said appeal, the opposite party number 3 page 141 directed the petitioner to deposit first the demanded amount and for a appeal afresh. Thereafter, my lord, the petitioner deposited the demanded amount, which has been annexed at 12B. My lord, thereafter file the fresh appeal, that is appeal number 01 of 2021, and the appeal number 01 of 2021 will be disposed of by the opposite party number 3, that is the impugned order, which has been challenged by the petitioner.
How does instructions? Mail. The clients would not suffer.
Listed by Thursday. It's a PIL. I was hoping to get it listed on Thursday.
Make a mention.
This is not the mention time unless matter is.
Much obliged.
My lord, apologies, my lord, item number 11, which my colleague has just passed on the batch matter.
All
the
right,
interim production.
We will see.
Eleven is there. Oh, that is that. And is that postpaid?
All right.
No specific date has been given.
Must have been fixed. No.
It was last 26/9 was the last date. given. Maybe
All right, we'll see.
My lord, interim protection till the next date of hearing may be given, my lordship, similar to other batch of matters.
Yes.
Okay, was there.
Yes, deeply obliged.
Item 6 plus 2 came. Item number 26.
Yes, Mr. Singh.
My lords, the matter appears to be a very lengthy and complicated case. But my lords, there are basically, when I read everything, there are basically two legal issues which are involved, my lords. In a very brief, before I come to the list of dates, and my lords, take my lords along with that list of dates. The first legal issue, my lords, is that is the issue that COVID-19, the biggest calamity of the century, which brought our country to a grinding halt, is this issue still undecided that it is a force majeure? Is it still res integra? Or in the light of the observation done by the made by the Honorable Division Bench earlier, this had one round of litigation earlier also, my lords. That order came in 2020 December. 20 December. My lords, there are detailed observations that the country had come to grinding halt. It cannot be the case of the state government that the lessees were not constrained to take away their iron ore from the site. So it is a great analysis done by the Honorable Division Bench. And towards the end, in the last para, they say, in light of all the discussions which we have made, we still give it to the competent authority to decide. So, my lords, this is the observations of the Honorable Division Bench, which was binding on the mining secretary. Two, my lords, during this period, the apex court, the Supreme Court, in various cases, but two cases, my lords, I will cite and show in great detail. One is Chowgle 1 and Chowgle 2. And then there are Mid-East. And Mid-East is a case of Orissa, my lords. And several IAs were filed before the apex court. And the apex court held and said that because of the COVID-19 situation, because of the constraints, we are extending time 2 months, 4 months, 6 months, 6 months, 6 months. My lords, so therefore the observation of the division bench. Then, my lords, the decisions of the apex court. And the third is that, my lords, after 2016, this has been made a statutory right in the sense that earlier it was part of our lease deed. Form K had a provision whereby it was said that everybody gets 6 months to lift their iron ore minerals from the site. But in the lease deed, which were later made a statute, and it is 12(1) FF of the MCR, which came in 2016, which says that, which uses the word force majeure, that whatever is the period of force majeure, it will be added to the time already granted by 12(1) GG. So a right which was earlier just a contractual right, now made a statutory right. So in light of all these, the first issue is this force majeure, COVID-19 is a force majeure, is it res integra? My lords, my humble submission is, it is no more res integra. Since having been decided by the apex court, force majeure, if I think, my lords, force majeure, they conceive of situations where there's a auntie, there's a storm, there's a massive floods or something. Nobody imagined what is going to come in 2019. And, my lords, everybody went through this. And whatever data later on has been provided, the COVID-19 situation was a fact which was to be seen. There were people who were running away to their village homes.
That is one question. Even if it is not disputed, that was a situation which comes within this force majeure clause. But what are the consequences? See, we cannot also forget, we cannot ignore the fact that there were people who derived advantages out of it.
Because there were a lot of people who were indulging in black marketing and all that.
Whatever, not only even legally, they many people might have earned because of that situation. So can they, therefore, what is the exact consequence of and how the writ court under 226 shall enforce that? These are the whether this is not a situation where the state government or the central government, whosoever is the competent authority, should come out with a policy specific on this. Or they may take a stand that yes, there was nothing like a pandemic for you. You had all the advantages, and therefore that policy may be tested. But first of all, they should frame a policy. This is what, speaking for myself, prima facie.
Milot's, I agree to Milot's observations about a lot of people making money during the COVID and benefiting.
I'm not saying that.
No, Milot, I understand.
My statement is in a different context. That the consequence of that,
of the COVID,
the factual aspect, whether that can be gone into in a writ proceeding, can we decide specifically that yes, this right you are entitled to, despite Rule 12A, 12HH. 12HH is
the extension is
12(1)HH. Yes, 12(1)H is of the rules. Despite that, whether you are entitled to or not. So whether it would be better for the state to come out with specific policy or not. Forget that part of the observation when I said that many people might have derived advantages out of many ways.
Milot's, regarding the power of the writ court and the adequacy or the justifiability of the writ court going into this question, Milot's, while during my submissions, I'll show the consequences of what happened in COVID-19 and how it happened because of reasons beyond me.
All right.
It happened because of the district magistrate's order. It happened because of the government of India's order. It happened because of the state government's order. It happened because of lockdown order. 1, 2, 3, 4, 5. So, Milot's, in fact, when we go through the during my submissions, we'll go through all that chart. So, huge amount of constraint put on any person, which is apparent on face of record. So, if all that is seen, then, Milords, the writ jurisdiction 226 as it is so wide that if 12(1) FF says that you are the competent authority, you apply your mind and then give a reasoned, fair decision, whether force majeure affected it. And especially in this case, my lord, since the Honorable Division Bench had already analyzed the whole situation and he had declared that the state's position cannot be admitted, that there was no constraint on them. So he was saying in so many words, my lord, we will go through the judgment, my lord. The Honorable DB was saying that force majeure is there, constraint is there. Nation was in a grinding halt for at least 3 months. That is his observation. Therefore, my right under 12(1) FF, at least for 3 months, nobody can dispute. As per that observation, what application of mind the Secretary Mines had to do, and I'm presuming a bit, my lords. The presumption is that since everybody's situation was different, my lords, the Honorable DB has used the word, go and see case to case and facts of every case. So, my lords, if somebody has just 10,000 tons of iron ore, he does not need 6 months. Somebody has 3 million tons to lift. There are approach problems. There's some persons have a railway siding within their mine. Some people don't have a railway siding. Some people are on the national highway. Some iron ore lessee are not on the national highway. So that was the discretion left to the officer, that you go through case to case. I have decided and declared that the nation had come to a grinding halt at least for 3 months. So 3 months to Milords is the observation. So Milords also has to see that after the observation, Milords, in fact, so let's see what Apex Court has done. Apex Court did not go into all those details. COVID, you have not been able to lift 4 months. COVID, you have not been able to lift 6 months. Milords, they could also have probably said that competent authority will decide.
No.
142, Milords, they did not use. Milords, they did not speak about
the power which can be exercised and the powers which have been exercised by the Supreme Court. You may be referring to some of the decisions also. Those powers cannot be exercised by the High Court. Those powers were exercised invoking 142.
Basically,
we will see.
At the basic level, my lords, if the order is unfair, unreasonable, not based on facts, Then Milots has all the powers to.
When you say that an order is not based on facts, we can go into that. But if the law requires something, if the law commands, then we are bound by the law.
It's exactly, that is what my submission is.
Yes.
If the state government is bound by the law to give.
Yes. So I miss to see
12(1)
that provision under the lease agreement which you are referring to.
It is the same as 12(1) FF now.
12(1) FF.
Milots has 12(1) FF. It is at page 47.
12(1) FF, yes, it is there.
The Minerals, Mines and Minerals Development and Regulation Act 1957, but pages may be different. The Mineral Concession Rules, Milots, 2016.
Yes.
The 12(1) FF, Milots.
Yes.
Milots has that?
Yes.
Let me read. Failure on the part of the lessee to fulfill any of the terms and conditions of the Act and rules made thereunder or under the mining lease shall not give the central government or state government any claim against the lessee. That is the claim which they are passing by seizing my property, or be deemed a breach of the lease insofar as such failure is considered by the relevant government to arise from the force majeure. In the event of any delay by the lessee to fulfill any of the terms and conditions of the Act and rules made thereunder or under the mining lease on account of force majeure event, the period of such delay shall be added to the period fixed by these rules or the mining lease. Further it goes, in this clause, the expression force majeure means act of God, war, insurrection, riot, civil commotion, strike, earthquake, tide, storm, tidal wave, flood, lightning, explosion, fire, earthquake, and any other. Well, let's say they did not know that COVID is going to come. And any other happening which the lessee could not reasonably prevent or control. So, Milots, this 12(1) FF, which has now been a statutory provision, earlier was just in the standard form K of the lease deed agreement. So, Milots, here a right has been given that lease deed contravention or extension or some act or rule. So, Milots, may kindly see what they say in 12(1) GG. 12(1) GG. So, this is the standard time given to Milots, any lessee, to lift his oar. Milots, the lessee may, after paying the rents, rates, and royalties payable under the Act and rules made thereunder or under the lease deed at the expiry or sooner termination of this term or within 6 calendar months. 6 is the outer limit. Thereafter, unless the lease is terminated for default of the lessee, and in that case, at any time not less than 3 calendar months, not more than 6 calendar months after such termination, take down and remove for its own benefit all or any ore mineral excavated during the currency of the lease, engines, machinery, plant, buildings, structures, tramways, railways, and other works, erections and conveniences which may have been erected, set up or placed by the lessee in or upon the leased lands, and which the lessee is not bound to deliver to the state government or which the state government does not desire to purchase. So, Milots, this is what is given to me, 6 months. And it's a legislative policy which comes in 12(1) FF that if something untoward happens, which is not in my control, don't bind me to the conditions of the lease or the Act and rules, you have to extend. The only option which you have is actual determination whether I had the constraint or not. That is there in the consideration of the government. They have used the word in 12(1) FF. My humble submission, Milots, is that when you are making that consideration and deciding that whether COVID-19, did it constrain the lessee to lift or not, then you have to go by the empirical facts and evidences, which we have placed there. There are numerous orders, Milots. We will go through them, about 15-20 orders of the state government, central government, and the district administration, which says district magistrate as long as 2 months from 5 a.m. to 9 p.m. no truck shall ply. It is even after the lockdown was lifted. And I was operating in that district. So, my lords, all these constraints have to be taken into fact. And what happened, my lords, when this matter went to the state government for the second time after the observation made by the DB, my lords, I read that order passed by the mining secretary. If I see all that order, the crux of that order is that the situation during COVID was better than the normal. In fact, there are statements which say that this data...
less traffic.
Less traffic and so many other things, my lords. If I'm not allowed to ply my trucks, if there's no traffic, how can I take the advantage of all that? My lords, he has also annexed annexure 1, 2, 3, 4, 5 to his impugned, that is the impugned order, my lords, of past on 5th May. My lords, the direction of the Honorable DB was that you go case to case. So you see what is the constraint for this lessee and see whether he requires how much time. That, my lords, I will read the judgment of the DB. After this, I'll go to the judgment of the DB, my lords. So the DB had not left that option or discretion to him. Though in para 60, the DB said he will leave it to the competent authority to decide this, but not decide whether there was force majeure or not. Because earlier observations were already there that nation had come to a grinding halt for 3 months. The earlier observation, it cannot be admitted, the submission of the state government, that there was no constraint on lessee, which is a matter of fact, my lords. Who can argue and say that during all this period, there was no constraint? The workers who used to lift the ore and put it there or the work in the mines, they had all left for their villages. Either they have left for villages or not working. They were in bad situation. The nation was in complete grip. So this is stand, my lords. And I'm just, my lords, saying that after the observation of the Honorable DB and also the Apex, my lords, we also have to see Apex Court why they have given. The IAs have filed and they have discussed the details of the constraints they have. So after looking at the constraints which the IA of the Mideast, the Apex Court said, yes, 6 months. In fact, I was told one of the lessees is still lifting it for 1.5 years. That's a fact I was told, my lords. So it is my property and something had happened which constrained me. So the state government cannot completely turn away blind and say, my lords, kindly imagine if this provision of force majeure giving extension to there is there in the statute. If it is not granted in a situation of COVID, which is once in a century phenomena, when will it be given? In a local storm? In a local flood?
Is it your submission that no relaxation at all has been given by them?
No relaxation.
Zero.
Not me, my lords. So many. Therefore, there are a list of cases which, my lords, are listed together. Not even one day after the observation of the Honorable DB that the nation came to a grinding halt for 3 months. Not even one day, to me at least. So, my lords, and the second legal issue which my lords, this. Another provision is there, my lords, which I also read, so that 12.1 GG, 12.1 FF, 12.1 HH completes, because this is what we have to see here. So they have acted under 12.1 HH, my lords. I'll just read 12.1 HH. One HH. Yes. They have acted under 1 HH. When they reject your application under 12.1 FF, then before they try to make their own property, 12.1 HH is where they resort to. Well, it's 12.1 HH. If at the end of 6 calendar months, after the expiry or sooner termination of the lease term, there shall remain in or upon
the lease land. Yes, we're ready.
Remain in or upon the leased land any ore or mineral, engines, machinery, plant, buildings, structures, tramways, railways, and other works, erections and conveniences or other property which are not required by the lessee in connection with operations in any other lands held by it under prospecting license or mining lease, the same shall, if not removed by the lessee within 1 calendar month of being notified to do so by the state government, be deemed to become the property of the state government and may be sold or disposed of in such manner as the state government shall deem fit, without liability to pay any compensation or to account to the lessee in respect thereof. My lord, so what invocation of 12.1 HH does is that 6 months is granted by 12(1) GG. Some lessee, well, let's say imagine there was no force majeure or no COVID. Then the state government has to give a notice under this, and they give 30 days. After 1 month time. After 1 month time, all the plant and machinery which are supposed to be removed under 12(1) GG within 6 months, and the ore becomes the property of the state government. So this is a harsh measure. It is necessary. At situations, it may be necessary because the state government may give the lease of that mine to some other lessee. So the earlier machinery, plant, iron ore has to be removed from there. So it's a necessary provision, but this cannot be resorted to unless they have rightly considered my application or representation to apply their mind in the light of the observations made by the Honorable Division Bench that look here, we have said all this, we have analyzed this situation, and you shall take decision in light of all that. So Millards now completely deny, not giving me even 1 day to remove my ore. They have resorted, they passed Millards this note, they issued this notice on 24th May 2021. And after 1 month, they say now it is my property. And Millards, this is an irony which I'm just trying to place it here. This iron ore for my client, Millards, because of an order of Honorable Supreme Court in 2017, they had said that you had gone on to mine without getting the EC clearance. So you shall pay the market price again to the state government. And in compliance of the order of the Apex Court, I deposited more than 1,100 crores. And Millards, I will also show the facts of Mid-East. Mid-East was also similarly placed. They were to deposit 900 odd crores. They had no money, could not deposit. Supreme Court said all the iron ore which you are lifting now beyond the 6 months, which they granted the extra time, now you will deposit the entire amount with the state government. So Millards, this is a situation which will be a double whammy to me, that I have paid everything which I would have paid at the time of taking the lease. Then said, no, you did not have an EC clearance. So it's a harsh order comes. You pay 1,100 crores. Otherwise, your lease will be terminated. I pay upfront 1,120 crores. And then when I'm going to lift that thing, I'm told that no force majeure, no COVID, no constraint. You go away. This is our property.
Just a minute, Mr. Singh. Just a minute.
That gives judgment.
So please come to HH.
Millards.
What does this refer to? The same shall, if not removed,
Millards, which line?
by
Millards?
the lessee, HH 1, 2, 3, 4, 5, 6, 7. If not removed by the lessee within 1 calendar month of being notified to do so.
By the state.
So what is this?
Millards, they say that since Millards, this is what I was saying, Millards, that on 24th May 2021, they issued that notice.
So that notice was issued?
Issued.
This was the notification?
Notice was issued, Millards. That's there. So this notice was issued, and 1 month, they say, after 1 month, say the stand of the state government, it is everything is right.
24, which is the
24th May 2021.
Yes.
Millards, everything originates from the earlier round of litigation, Millards. And Millards, all these issues were Millards placed and submitted before the Millards, the Honorable Division Bench, and then they have made certain observation. Millards, kindly see.
In the first case.
This starts from page 171. Millards, this is the annexure 3 of the writ petition, Millards.
In the first case.
Yes.
This is the first round, Millards. And Millards, may kindly see our case number is 27731. And the name is Ramesh Prasad Sao.
Ramesh Prasad Sao is 17796. isn't it?
In here, my lords, I'm quoting the number of the previous litigation, my lords, previous rate. So, my lords, all the cases have been discussed in detail separately. So, my lords, we can come to straight to page 206, where our case has been discussed by DB, my lords, Honorable DB.
Annexure 7.
This is Annexure 3, my lords, and we are
Annexure 3.
Annexure 3.
Yes.
It begins at 171, but
Yeah.
my lords, kindly see page 206, where internal page 36, where my lords, my case has been discussed in detail, my lords.
Page 206,
my lords.
Yes.
My lords, before I start reading this, my lords, one legal issue which I had not placed before, that was first there was the force majeure, whether it is still res integra. And the second, my lords, is that it appears that it has to be decided, my lords, whether it is my legal right, a statutory right to get this extension, or is it the discretion of the government? Well, this is a main legal issue, because it appears, reading all the counter filed by the state government, they are harping that as if it is their discretion. If I say yes, it is yes. If I say no, it's no. So it's like that. It's I'm going to give you an arm, or I will not give you an arm. My submission, my lords, here is this legal issue, that it is my statutory right, especially in light of the force majeure. Now, my lords, I read from page 36. Writ petition civil number 27731 of 2020. Para 25. This writ petition has been filed by Ramesh Prasad Sao, challenging the order 110/2020 wide annexure 1. Mr. Parag Tripathi, learned senior advocate, appearing for the petitioner, while admitting that the mining lease of the petitioner expired on 31/3/2020, but no fresh lease involving the leasehold area enjoyed by the ex-lessee has been granted. So my lease came to an end on 31st March. It is contended that the state government, by general order dated 31/3/2020, granted a period of 6 months in purported exercise of its powers under Rule 12(1) GG of the rules of 2016 to remove raised mineral, plant and machinery, etc. In the meantime, Government of India clamped the lockdown at national level due to outbreak of COVID-19. So unfortunately, the end of my lease period was when the lockdown had begun. The petitioner made all possible efforts to remove the entire quantity of minerals. However, due to supervening circumstances following lockdown imposed by the government for the reason of COVID-19 pandemic, he could not do so. It is also claimed that the transportation got affected due to innumerable obstructions, such as due to sudden lockdown from the last week of March, the workers left for their native villages. There was also mass reverse migration. Lockdown also severely affected all sorts of human activities, resulting in reduction in the capacity of industries, including steel industry. There also came vehicular restrictions, thereby resulting trips to different port areas being minimized due to capping on the number of trucks by the district administration. Even then, the petitioner attempted to acquire plot for storage of minerals to take advantage of the circular dated 4/10/2019. They give an alternate site where you can put your, I don't know, it's talking about that. But he could not succeed, particularly because entire stock of petitioner's mineral was to be transported to port areas like Paradip and Gopalpur. It's a low quality iron ore. Iron grades are there. So low grade iron ores have to be exported because the technology to make steel out of them is not available in this country. He had already acquired plots. Therefore, there was no occasion for the petitioner to divert its transportation elsewhere. Referring to the documents at running pages 136, 139, 142, and 142 of the brief, Mr. Tripathi, learned senior advocate, contended that there was also capping of plying of trucks. The capping was done by the Joint Director of Transport, which drastically reduced the transportation capacity of the petitioner, drawing attention of the court to the notification issued in October 2020 by the Ministry of Road, Transport and Highways at Annexure 18, Office Memorandum issued by Ministry of Finance, Annexure 19, additional affidavit dated 2/11/2020 and also referring to Annexure 21 to 24 with rejoinder affidavit. Mr. Tripathi, learned senior advocate, submitted that there is universal acceptance of the pandemic arising out of the outbreak of COVID-19 being a circumstance justifying invocation of force majeure clause. There cannot be a better position than this for application of force majeure to the case of the petitioner. Taking this court to the impugned communication dated 1/10/2020, it is argued, my lords, what happened that on 1/10/2020 in the earlier round, the Mines Department issued that notification where they say that after 30 days, the property will become mine as per the 12(1) HH. It is argued that this order has been passed without appreciating or even referring to the application of the petitioner dated 29/9/2020, wide annexure 3 pending consideration with the competent authority. Because now, since our application for extension on ground of force majeure had been given 3 days prior to his passing that notice order. So, my lords, the next pages deal with, reasonable opportunity of being heard, principles of natural justice. My lords, I will skip all that because in this round, we have been given principles of natural justice. And that's not our case that they passed an order without hearing us. They heard us. They took a written submission from us. So my lords, I will skip page 39 because this talks about that. My lords, then my lords may kindly come to 211, page 41. It begins from the last 3 lines. It is submitted. My lords has that.
Which page?
Internal page 41, writ petitions 211.
Yes.
My lord, may I read?
Yes.
Now they are talking about the Honorable Apex Court judges. It is submitted that the decision of the Supreme Court in Chowgule and Mid-East have direct application to the case of the petitioner. Even with this case was argued, my lords, in month of October 2020, those 2 decisions had come. Some extensions on ground of COVID by the Apex Court had come. So it was pointed out. Have direct application to the case of the petitioner, advancing his submission that since the minerals was raised during the validity period of lease by the ex-lessee and such are his property, if acquired by the state will be hit by Article 300A of the Constitution of India. Mr. Parag Tripathi, learned senior advocate, relied on the judgment of the Supreme Court.
How is he, Mr. Parag Tripathi?
Well,
how is he? Is he, Mr. Parag Tripathi?
Well, I know of nothing wrong with him. Well, he's fine. Well, he was the dean in campus law center.
Yes. Therefore,
Mr. Parag Tripathi, he's
all right, please continue.
He's all right.
Just his face came in my mind, therefore. Must be a friend of Mr. Subramaniam.
Very distinguished friend, my lord.
Very distinguished friend, as
yes, please
continue. It says. Will be hit by Article 300A of the Constitution of India. Mr. Parag Tripathi, learned senior advocate, relied on the judgments of Supreme Court in BK Ravindra Chandra and others versus Union of India, reported in 2020, SCC Online, Plantation Private Limited and others. They are arguing on the basis of Article 300A that this is my property. You just by notification cannot take that. I'll skip that because that is one of our submissions, but not our main submissions.
Yes.
Now, from page 213, the Honorable DB is discussing other cases. So we will come to straight to 47. Page 241, the findings are begin from paragraph 47.
Yes.
Page 46. Para 46. We have given our anxious consideration to rival submissions, carefully perused the materials on record, and respectfully studied the cited precedents. 47. On consideration of the factual position and the legal submissions made by all the learned senior advocates and other counsel representing different parties, this court finds that writ petition number so-and-so filed by A.S. Ahluwalia seeking to challenge the order dated 1/10/2020 on the ground that it was passed while keeping representation of the petitioner submitted on 19/9/2020 pending, which was later rejected by the order dated 9/2/2020. Similarly, writ petition number 27751 filed by Mrs. Kalinga Mining Corporation involves challenge to both the orders dated 1/10/20. May not read that. Top of the next page, our case is discussed. Likewise, in writ petition number 27731, that is Mr. Sao's case, filed by Ramesh Prasad Sao. Also, the petitioner has challenged the order dated 1/10/2020 and the rejection of the represented Annexure 3 by the order dated 9/10/2020 by raising the same arguments. Well, now the Honorable DB has dealt with the common grounds from the second para of page 72 minutes.
Yes.
From the factual narration indicated herein above, this court finds the common thread running through all these cases is that their lease stood expired on 31st March 2020. All the parties have been served with notice dated 1/10/2020 upon invocation of power under Rule 12(1) HH and the rule of the rules of 2016. In 3 out of each 8 writ petitions, there have come new leases, wherein 2 of them ex-lessee have become the new lessees. In one of the cases, it is observed that mine of the leaseholder is a non-performing mine. There is also a case, which I may not read that. Mellots, may kindly come straight to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from page 243. Same page, 10th line. All the writ petitioners, Mellots has that?
Please.
All the writ petitioners have approached the court with a common plea that they faced enormous difficulty in their affairs involving transportation of raised minerals, plant and machineries, etc. And in some cases, only mineral. One of the cases involved the transportation of plant and machinery. A common argument has been advanced by the learned senior advocates appearing in all the writ petitions that towards the end of March 2020, the country in the wake of COVID-19 pandemic faced unprecedented situation leading to 6 phases of lockdown, intended to avoid spread of coronavirus. In the first stage, with implementation of full curfew, while in some part of the country there was weekend curfew, and later in some other parts of the country witnessed night curfew, which process continued with some modification or other up to stage 6 lockdown. Then the country introduced unlock 1 and onwards, which is still continues. All learned senior advocates appearing for the petitioners were unanimous in their submission that situation in the country as a whole was so chaotic and everybody was under trauma. It is in reference to the different notification introduced at the national level as well as the state level that almost all advocates admitted that though there was no restriction on paper insofar as mining activities and transportation of minerals are concerned, but on the ground, the situation was totally different. Because what had happened on 24th March, there was an order of lockdown. And 25th March, the government of India came out with a notification that they said certain items are exempted. And they exempted mines. So this is one of the grounds taken by the other side, since you are in the exempted category, so therefore you can't take that plea. Exemption in paper and actual being able to lift the ore and take it to the port or to the buyer is a completely different story. Looking to the nature of direction issued
what are the 2 dates?
What
are the 2 dates?
24th March, national lockdown was imposed by Government of India, and 25th March, they issued a notification. It is part of the pleadings, I'll show Milots. On 25th March, they issued a notification saying that certain activities or objects are not under the restriction. Essential commodities was one, mine minerals was another. So, Milots, that is which came on 25th March. So therefore, this talk of no restriction on paper insofar as mining activities and transportation of minerals are concerned. But on the ground, the situation was totally different. Looking to the nature of discretion, direction issued at both levels from time to time, there has been tremendous fear amongst the citizens of the country. Bringing to the notice of the court some of the circulars, it has been argued that in view of the variety of restrictions, there have been different types of dislocations. Instances have been cited showing shortage of the manpower, rampant migration of laborers, closure of eateries on the roadside, on the national highways, as well as state highways for indefinite period, making it horrible for the drivers and other persons engaged on truck transporting such minerals, thus causing immense difficulties thereby, resulting reduction in the availability of the trucks, manpower, stoppage of movement of citizens due to lack of means of transport, and several other restrictions, almost bringing the entire, Milots, kindly note, almost bringing the entire nation to grinding halt at least for 3 months. And Milots, when the DB says that take a decision in light of our above analysis, they say that 3 months to Milots is complete grinding halt. And it is not the case of anybody that after grinding halt of 3 months, everything suddenly became free. So grinding halt is one stage, and then slowly opening up the economy, opening up the transport, opening up all the facilities and taking away the restriction is another story. So at least 3 months, he says, grinding halt. Our case would be 3 months grinding halt, but also when it was unlocking slowly. As the times passed, some district administration imposed day curfew. Some in our district, Millots also, it was day curfew. Koinchar. Some imposed night curfew and some imposed week curfew. Some imposed weekend curfew. It also commonly urged that the state district administration introduced capping on the movement of trucks. Thus, this mine owner or this lessee will have only 220 trucks to go to this port. In my case, Millots, probably in our intention to carry the iron ore quickly, probably 1 or 2 extra trucks were utilized. They immediately came with a notice. What have you done? We only allowed you 220. Now they say there's no constraint. To different destinations, creating uncertainty involving transportation to other areas, fall in the market position in the whole world created deterioration in the financial condition of every individual. It is urged that this all resulted due to COVID-19 pandemic. Therefore, the state government cannot be allowed to contend there was no effect whatsoever on ex-lessee. Therefore, the state government cannot be, it's coming after full stop. Therefore, the state government cannot be allowed to contend that there was no effect whatsoever on ex-lessee. In this situation, when the National Disaster Management Authority declared this pandemic to be a natural calamity and the central government taking into consideration of the situation, issued various notifications and circulars providing relaxation to different types of business activities, financial incentives, introducing relaxation in a variety of areas suffering due to the pandemic situation in the country from March to October 2020, including the one issued by the Ministry of Mines. This court is inclined, what more clear instructions can be given to the state government authorities who is still completely ignoring the directions. This court is inclined to hold that the state government was under a statutory obligation to examine the grievances of the petitioner, whether or not they have made out a case for invoking force majeure role in Rule 12(1) FF of the Rule 2016. This court is inclined, this is para 49 Millots, next page, to uphold the arguments, inclined to uphold the arguments that the representation of the petitioners could not have been rejected as not maintainable because force majeure clauses are very much included in the lease deed as one of the condition, and it is also available in Rule 12(1) FF of the rules of 2016 to be invoked at the stage of Rule 12(1) GG. The competent authority of the state government ought to have therefore examined such application, representation of the petitioner on the basis of whatever material they relied in support of their claim on case-to-case basis. Millots, here is what it is. The situation, Millots, the Honorable DB did not go into that we are giving you omnibus 6 months or 4 months. You take case-to-case basis. They have asked for force majeure, see what difficulties they have faced, see what are the circulars they are placing before you, see the orders of the district magistrate they are placing before you, which was restricted. The state government was capping the number of vehicles available to me. See, look at all this and see how much relaxation can you give on case-to-case basis and decided them by speaking and reasoned order rather than hushing them up by describing as not maintainable. Now, Millots, they have also said something about lot of applications for getting clearances were not coming rapidly from the government. This has been observed in the next page, Millots. Millots may kindly also at the last line of this page, Millots, 76, also attempted to get additional time by simultaneously relying on force majeure clause for they're also suffering due to COVID-19, but primarily they suffered due to lackadaisical approach on the part of the state functionaries. The writ petitioners have thus successfully demonstrated that the competent authority, the writ petitioners have thus successfully demonstrated that the competent authority of the state government has mechanically invoked Rule 12(1) HH in passing order dated 110/2020. Well, the situation is worse in this case. Well, the mine secretary who had invoked 12(1) HH then in 2020 did not have the, well, at least I would say, the analysis available to it by the Honorable Division Bench. The order which has passed in 5th May, well, this analysis was available. So even then, if you don't see that there is no constraint and everybody's claim was rejected even for a day, that, Millots, is unfair, to say the least. And Millots, I just wanted to point one thing which I missed. I noted down this. Millots is aware about the suo motu case, where the Limitation Act, which is such a strict act, And my lords, the Honorable Apex Court gave more than 2 years of relaxation on account of COVID. Otherwise, if somebody says the Limitation Act is a very, very strict act, even a delay of 1 day has to be explained. And then, because everybody was sensitive to
Did any High Court grant such exemption?
My lords, but I think, I'm not aware, my lords, but since the order was from the Apex Court, the High Court also.
The High Court exercised its jurisdiction under Article 140.
No, but in CLAT matters, this suo motu cases extension of limitation is applicable.
No, it's applicable because of the orders.
I'm not on competence, my lords. I bow down.
Therefore,
I bow down here completely to my lord's observation.
Therefore, I put this question: that whether the relaxations which were granted by the Supreme Court, such relaxations were granted by any High Court in any case. It cannot be done.
We'll show that judgment, my lords. At this point, my lords, I just want to make 2 submissions. One, my lords, is that the jurisdiction of the Honorable High Court is much wider, my lords. And the point which I was trying to stress by giving this example is about the sensitivity. It's not about competence. I said, my lords, it was felt that this is the need of the hour to ameliorate the difficulties which the citizens were facing.
Yes.
Well, it's my learned friend points out that the judgment of the Apex Court in Chogle 1, Chogle 2, which Miller said so, is not under 142. It's a normal SLP order.
The orders were passed on a petition filed under Article 136.
Millets.
But still,
the powers is there.
Powers are exercised.
I bow down, Millets. May I continue? This court is inclined to hold that there was this I have read, Millets. Now, Millets, I have read also this 76, the lackadaisical approach. Now, Millets, yeah, there are this. पेज बताइए Well, let's kindly see on page 247, para 50. The court on examination of the individual cases finds that the petitioners in the first category of cases made representation seeking additional time for transportation of minerals as well as plant and machineries, whereas the claim of the petitioners falling in second category was based on the fact of old lessee becoming new lessee.
Yes.
So, Millets, they have differentiated. There are 2 categories. We are in the category where our lease terminated on 31st March and we are not new lessee. We are no more lessee. Now, Millets, let's kindly come to para 76, Millets, at page 275. Now, this is the 1, 2, 3, 4.
Internal page?
Page is internal page 105. And the petitions page 275. Read petitions page. Millets has it?
Yes.
Para 76. Considering the case of the petitioners from the perspective that despite peculiar and different facts of different cases, non-consideration of each individual cases separately invoking Rule 12(1) GG, while representation of the petitioners were pending by the order dated 1/10/2020, and then rejecting all the representation by identical order, cryptic and non-speaking orders by order dated 9/10/2020. This court is inclined to hold that this is a fit case of exercise of its powers of judicial review by requiring the respondents to consider the representation of the petitioner, at least in the first 5 of the above writ petitions. We are one of the 5 amongst the students whose lease had ended. Anterior to the stage of invocation of Rule 12(1) GG of the rules of 2016, when such representations were pending with them and straight away allowed last 3 writ petitions, wherein the petitioners have either not invoked force majeure event or this is not relevant. But let's come to para 77. On analysis of the entire material on record, we are inclined to hold that the petitioner in 5 writ petitions, that is our number is 27751, wherein they have mainly prayed for invocation of force majeure clause with reference to clause 4, 5, and 6 of part 9 of the lease deed executed on Form K under the MC Rules 1960 and Rule 12(1) FF of the Rules of 2016. So two documents are supporting us. One is a contractual lease deed and the other is a statutory rule. The impugned order dated 1/10/2020 passed by the opposite party authority invoking Rule 12(1) HH while keeping representation of the petitioner pending an order dated 9/10/20 while dismissing the representation of the petitioners as not maintainable, having been passed without considering any of the arguments. My lords, unfortunately, we stand at the same stage after 4 years. My lords, one thing, my lords, which I noticed, in the first round of litigation, it ended in 2.5 months. This round, it is going on for 3 years. It was filed in 2021. My lords, somebody's property which is lying. If it comes to me, the more the delay, the more difficulty I face because the capital, I've already paid 1,100 odd crores to the state government as per the orders of the Honorable Court. My hands are tied. I can't lift my own oar. The judgment of Chocolate 2 Milos also says in para 35 that iron ore which is lying at the site is the lessee's property. So declared it is my property. But don't touch your property. That's the mandate of the state government, saying there is no COVID, no effect, no consequence, no constraint. You can't touch it. We will not extend your period even by a day. My lords, while dismissing the representation of the petitioners as not maintainable, having been passed without considering any of the arguments of the petitioners, that the force majeure event is attracted in the circumstances of their case, deserves to succeed in part. We therefore, while partly allowing all the above said 5 writ petitions, set aside the order dated 1/10/2020, invoking Rule 12(1) GG of the Rules of 2000. This is a typo error.
It should be
HH. It should be HH.
Yes.
12(1) HH of the Rules of 2016 and the order dated 9/10/20.
No, which paragraph you're reading?
Well, it's page 106.
106, yes.
Sir, page 106, internal page. And it is para, let's have asked, it is para 77. And I'm reading.
All right, yes. So instead of GG, it ought to have been HH.
Of the Rules of 2016 and the order dated 9/10/2020, rejecting the representations and remand the matter to the Principal Secretary, Steel and Mines Department, Government of Odisha, were considering representation of the writ petitioners afresh in the light of discussions made above. My lords, this is the crucial order. My lords, it does not say that you just apply your mind and decide. Well, it was the mandate of the Honorable Division Bench that we have gone into a great deal of discussion. And in light of the above, kindly take your decision. My lords, my interpretation is that what was left to the discretion of the state was how much time each lessee needs practically, depending on what kind of constraints he faced, A, B, how much iron ore is there, and C, what is the distance from the main road or whether he has a railway siding or not. Well, that's what happens like in our mind. Today, OMC is operating. There is one-way bridge. So tomorrow, if I'm giving a time, they have asked me, I have put an additional affidavit. What is my evacuation plan? It was asked by the Honorable Court. So evacuation.
When was that question put?
The round 1.
Yes. Then is round.
It's this round only. So we have given 2 alternate evacuation plan. One, when we are given full cooperation from OMC, because there is a common way bridge and there's common way, their stock is also coming out. Ours are already lying there. And a situation B, where there is no cooperation from them. So in this scenario, maybe 6 months, but no cooperation, maybe much more. So therefore, Milots, case to case was the direction, Milots, for the state authorities to see how much extension. Milots, in my view, the Honorable DB did not want to give an omnibus 6 months, 8 months, 1 year. You see how much ore, how much difficulty, what constraint did he face. So see all this and pass an order. Pass an order after looking at the representation. I file a representation, Milots. I cite the orders of the apex court. And Milots, very conveniently, the order where they completely rejected Milots, they do not even, Milots, speak about that. If I have argued something in my written submission I have given, in my representation I have said, Milots, this is the order of the similar situation, similar condition. And one of Mid East is a matter of Odisha. Milots, they are abiding, the state government is abiding, obviously they have to abide. So they are abiding by the order and they are aware. When I say they are abiding, they are fully aware that what happened in Mid East. And then they have not discussed this. My complaint is that they could have said, no, it was any reason, A, B, C, D. I'll not try to get into what reasons they could have given to ignore the order of the apex court. But they should have at least discussed that. They have not discussed. They have not discussed so many of our petitions. What they have done is given 5 annexures, which give a national and state data of 2016 onwards of what is the lifting, what is the iron production. You see there's a trend going up. You see there's a trend going down. I have lifted, my lords, the second largest iron ore during this period of 6 months. The only person who has lifted more than me is another company which has a railway siding inside his leasehold area. And I am the number 2. But then, my lords, the logic given is he has done it more, you have done it less. This is not case to case. He's taller, he's shorter, but I will apply the same rule to all of you. My lords, in fact, they have said in this review also, they have treated unequal as equals while they are deciding.
Yes.
10 June 2021 order.
Well, the order of 10th June. Melotz had asked that about when this order was passed. This order was passed, Melotz, on 10th June 2021 for evacuation, and it is quoted. Melotz, Mr. Rohatgi, learned senior advocate for the petitioner, states that the proposed schedule of removal of iron ore will be indicated in an affidavit by the petitioner, which will be placed on record by 17th June 2021. With an advance copy of the learned advocate general, who on the basis shall take instructions. Well, in light of that order, we had given an evacuation plan.
Yes.
We therefore, while partly allowing all the aforesaid 5 writ petitions, set aside the order dated 1/10/2020, invoking Rule 12(1) GG of the rules of 2016, and the order dated 9/10/2020, rejecting the representations, and remand the matter to the Principal Secretary, Steel and Mines Department, Government of Odisha, for considering representation of the writ petitioners afresh in the light of discussions made above. Petitioners would be at liberty to place all such materials which they have relied before the court, and may place any other material which they seek to rely to substantiate their case for invocation of the force majeure clause before the competent authority within 7 days, who shall then decide such representation by separate speaking and reason order in the each case within 45 days, and therefrom, after providing opportunity of hearing to the petitioners, it is directed that till disposal of the representation afresh by the competent authority, status quo with regard to the minerals excavated by the old lessee during the subsistence of the lease period, the plants and machineries, etc., lying in the respective leasehold area shall be maintained by the parties, which shall abide by the final outcome of the representative to decide with the competent authority. My lords, my intent of showing, my lords, all the observation of the Honorable DB was that it was not a simpliciter remand. There is a simpliciter remand.
No, your submission is that while considering your representations, they had to keep in mind the observations and findings recorded by the revision bench. That's all.
Absolutely. That's and this one is a direction that all the representation, all the grounds which they are making out, you consider all of them, and in the light of discussion above. So the light of discussion above goes back to about 10-15 pages. So this is from the DB, my lord. Now, my lords, I would think the next, my lords, would be to show, my lords, the apex court orders and the judgments which are
you're relying on.
Or no, my lords, on since one of the first legal issue which I had said.
Right. Whether it is statutory or it is the discretion of
It is the discretion, and also whether it is still, this question is still open, that COVID-19, especially, my lords, if it was a general order by apex court on some other issues granting extension, exactly same situation, same consideration, equally placed person, the Mid-East is slightly inferiorly placed. I say, my lords, not any offense meant. I say this because they had not complied with the early directions, and they could not cough up the amount which they have to pay to the state government. We paid upfront. Other than that, we are exactly similarly placed. And then they are allowed, given extension. Even Mr. Chowgle 1 and Chowgle 2, my lords, these 2 cases, the apex court has given their intention. So, my lords, I'll show that. Then I will go to the impugned order, how they have passed it. Chogle one. My lords, page 293, annexure 4, my lords.
Yes.
This is Chogle 1, my lords.
Yes.
And what had happened, my lords, this comes as just a prelude to Chogle 2. Because what is finally decided in Chogle 1 is that there was, my lords, a little confusion about the orders of the Honorable Supreme Court, that what did they mean by the order passed in Goa Foundation 2, case Goa Foundation 2. These were all iron ore leaseholders of Goa. So, my lords, that can be seen, my lords, at page 297, that this is the order with where there was a little confusion, my lords. 154.6, my lords, has that last paragraph of page 297.
Just a minute. Which paragraph?
Last paragraph of 297 marked as 154.6. They are quoting the Goa Foundation 2 case. Para 9.
Yes.
So, my lords, the para 9 opens with this. It will be opposite to refer to the conclusion directions given by this court in Goa Foundation 2 while deciding the said challenge.
Yes.
154.6, my lords. The mining leaseholders who have been granted the second renewal in violation of the decision and directions of this court in Goa Foundation are given time to manage their affairs. Because this was what was wrongly interpreted by the Honorable Bombay High Court. And, my lords, therefore, Goa Foundation went to Bombay High Court because they felt that manage their affairs means also to take away the iron ore. The mandatory 6 months will not be allowed to them. Manage their affairs and may continue their mining operations till 15/3/2018. However, they are directed to stop all mining operations with effect from 16/3/2018 until fresh mining lease. Now, what happened was para 10, on the next page.
Until fresh mining leases are granted and fresh environmental clearances are granted. Yes.
So para 10 will see what was the question before Chogle 1. It is the directions given in para 154.6 which has given to the present appeals. By the direction in para 154.6, the court gave time to mining leaseholders who were granted the second renewal to manage their affairs, permitting them to continue their mining operations till 15/3/2018. By the said direction, they were directed to stop all mining operations with effect from 16/3/2018. It is nobody's case that any of the mining leaseholders have continued the mining operations after 15/3/2018. The only question that arises for consideration is as to whether the minerals which were mined prior to 15/3/2018 can be permitted to be transported by the mining leaseholders or not. Now, Milots, para 13, they say, 12 also, Milots, construing the directions of this court in para 154.6 as restricting the mining operations till 15/3/18 and not restricting the transport of the minerals already mined till 15/3/18, the state of Goa, by a decision dated 21/3/2018, decided to permit the mining leaseholders to pay the royalty on the minerals which was already mined till 15/3/2018 and transport the same. Being aggrieved by the said decision, the Goa Foundation filed writ petition number 3 of 2018 before the High Court of Bombay at Goa. In the said petition, an interim order dated 28/3/18 came to be passed, whereby the transportation of all minerals was suspended. 14. The division bench of the Bombay High Court at Goa, while finally hearing the matter, also, after elaborate discussion, arrived at the following findings. According to our respectful interpretation, thus, when the Supreme Court mandated 5 weeks' time for arranging the affairs, it meant completion of transportation as well. So, Milots, this was the issue. And Milots, in this order, the Supreme Court, Milots, इसमें ज़्यादा दिखाने की जरूरत नहीं. Milots, may kindly come to page 300, para 24.
Yes.
para 24, Sri Rohatgi relying on Rule 12.1 GG of the minerals, other than atomic hydrocarbons, energy minerals, the same rules which we are talking, MCR 2016, would further submit that the legislative policy is to grant 6 calendar months to remove our material. Well, so he said that even in that order, 12.1 GG has to be read. So 6 months has to be allowed to them, Milods. And Milods, now Milods may come to this, kindly see this observation and the order of the court. On page 303. At first, Milods, at page 302.
Yes.
Yeah, Milods, at para 33, Milods, is also important, Milods. Milods, since this issue has come, whether it was discussion under 12.1 GG or 12.1 FF or not by the apex court. Milods, just for that purpose, Milods, Milods, I would like Milods to see para 33. It will also be relevant to refer to Rule 12.1 GG of the said rules. They have quoted 12.1 GG, every mining lease, and also they have, after quoting GG, Milods, they come to appraisal of clause GG of Rule 12 of the said rules would reveal that on the expiry of sooner termination, this is 6 months, they're talking about 6 months. Para 35 is also important for another reason, Milods, because it is a declaration that the iron ore which is lying over there is the property of the lessee. Milods, may I read 35?
Yes.
Para 35. Taking overall view of the matter, para 154.6 of the judgment, this court in Goa Foundation 2, the order.
In fact, Mr. Singh, 12.1 GG is not confined to force measure.
No, Milods. Therefore, I said
they have defined force measure.
Milods, I said at the time when I was Milods placing this order of the Honorable Apex Court, Milods, that this is a prelude to the chocolate.
No, our observation is something else.
Milods.
See, the force measure doctrine, as we understand,
Milods,
is not there under 12.1 FF. It is something more than that.
Milods.
Force measure finds some definition.
Milods.
For the purpose of those rules,
Milods.
like even the strike
Milods.
is a force measure.
Milods.
Civil commotion
Milods.
is a force. It cannot be force measure.
So it is wider than force measure. Milods is absolutely right. 12.1 FF. All the grounds for
12.1 FF gives a definition of force measure that is not confined only to what you are talking, what we are talking. It's a pandemic,
absolutely, absolutely, Milods.
Like even
so
if
many other things,
strikes, civil commotion, and other happenings.
Milods.
So
it's much wider than just the force measure. So several other clauses. In fact,
this is how we understand.
Milods, that's how it is, Milods. That's exactly how it is. They have cited several reasons, and in force majeure, they have given some examples and said any other. They have also added any other. It's like kind ejusdem generis that you can imagine what all will fall into force majeure. Milods, may I read para 35? Taking overall view of the matter, that is para 154.6 of the judgment this court in Goa Foundation 2, the orders dated 4/4/18 and 11/5/18 passed by the same bench which delivered the judgment of Goa Foundation 2 permitting the minerals iron ore to be transported, which were royalty paid and which was lying on the jetties on or before 15/3/2018, and the legislative policy granting 6 months period for removal of the mineral of the benefit of the lessee. We find that the view taken by the division bench of the Bombay High Court is not correct. If this court in Goa Foundation intended to prohibit the mining as well as transportation of the minerals with effect from 16/3, so Milods, this is the observation on Milods. The last line of this para, the last sentence, the fourth line from bottom of this para, Milods, it's important in the context of Milods, our case. Milods has that there is no doubt. There is no doubt that the ownership of the ore is that of the party that has raised the ore. The ore which has been permitted to be transported is on condition of the payment of royalty. We see no reason why the owner should not be allowed to transport their own ore. So, my lord, this was just trying to say that Apex Court has said that whatever you have brought out from the Mother Earth is your property. Now, my lords, comes chocolate. My lords, legislative policy, para 39, my lords. Taking into consideration of the legislative policy as contained in clause GG of the Rule 12(1) of the said rules, we direct that all such transportation shall be completed within a period of 6 months from today.
Yes.
So, my lords, this is not going into extension. The next chocolate 2 goes into the extension. But, my lords, I wanted to have this background that how that, because that order included the period of the COVID. So, my lords, they are aware, my lords, the Apex Court is aware of 12(1) GG, FF, HH, and then COVID is a ground where they extend the time. My lords, this may be noted this by this when this order was passed on 30th. 30th. So this is of January 2020 order, and my lords, the COVID comes on 21st. The lockdown comes on 24th March, 3 months later. So the extension period which was granted recognizing the lessee's right under 12(1) GG now falls in between the COVID period, peak of COVID. And Milos Chocolate 2, therefore I said it comes as a prelude. Now Chocolate 2 will show what view the Apex Court took, which is directly applicable to our case, Milos. It's relevant in our case. Well, let's next page, which is Annexure 5.
Yes.
It's at page 305. Because the para 1 says miscellaneous application number -- filed by lessee of manganese iron ore mine seeking extension of type for the transportation of minerals alleged to have been mined before 15/3/2018. Now, my lords, the relevant part is on 308 Roman 5, para Roman 5.
Yes.
Para 4 and then Roman 5. My lords, has page 308. Para 4, Roman 4. After so interpreting paragraph 154.6 of Goa Foundation, this court also took note of 12(1) GG of the mineral other than atomic rules 2016, which also allows a period of 6 months for the lessee to remove the excavated material. On the expiry or sooner termination of the term of lease, accordingly, this court, by its order dated 31/2020, granted a period of 6 months to all leaseholders to transport the mineral already excavated on or before 15/3/2018. Roman 5. The time granted by this court to the leaseholders by the order dated 31/2020 expired on 37/2020, which is between the middle of COVID lockdown period. A lockdown was clamped on 24/3/2020 due to the pandemic. Therefore, a few lessees have come up with the aforesaid application for extension of time by 6 months with effect from 1/10/2020 for the transportation of the minerals allegedly extracted by them before 2006. Now, let's at page 310, para 6. Para 6, Roman 2, we have they give 2 grounds on which they have asked for extension. The one was the delay because of statutory authorities delays, which Milots we are not concerned with. The other reason was the prayer for extension. The other reason, second reason was the imposition of lockdown within 2 months of the judgment of this court dated 31/2020. Milots, now page 311, para 9, bottom. From bottom of that page, para 9, Milots, kindly see. From the rival contentions raised in the applications for extension of time and the petition for directions, 2 issues arise for consideration. They are: 1, whether the right to remove the mine minerals is only in respect of the royalty paid ore or upon payment of royalty to the time of movement of disposal, and whether the state government ought to have invoked Rule 12(1) HH of the rules or not. Now, my lords, this is the question they are addressing. Now, my lords, page 313, para 14. Bottom of page 313. My lords, have it?
Yes.
14. Coming to the second contention, the same revolves around Rule 12(1) HH of the minerals and hydrocarbon energy minerals concession tool, which reads as follows. They have quoted HH. Now, my lords, the relevant para is 16 on page 315. Therefore, Goa Foundation may be right in contending that the state government should have invoked Rule 12(1) HH to confiscate the minor allegedly lying at the site for the past more than 2.5 years. But the difficulty today is that Rule 12(1) HH was not pressed into service before the court when this court rendered its judgment on 31/2020. As a result, the judgment dated 31/2020, giving 6 months time to the lessee to remove the material as attained finality. Now, my lords, para 19 is what is important, what they have finally hold, because this is relevant to us because they have talked about, my lords, the lockdown and the COVID. Para 19, 316, page 316. In the light of the above, the applications for extension of the time filed with the lessees and the applications for clarification directed filed with the government are disposed of to the following effect. The lessees are granted time up to the end of January 2021 for the removal of the minerals excavated, mined, on or before 15/3/2018, subject to payment of royalties and other charges. Well, this order was passed on October 13, 2020. Well, the extension was granted. And Milords, when I will place before Milords the judgments of the apex court in Mid-East, they have given in so many words that the COVID has come. The IA says that COVID has come. These are the reasons. And they have, Milords, said it so in so many words in that order that because of COVID, we are granting extension. Prayed by the petitioner. So, Milords, therefore, the first issue which I was raising, Milords, I was saying in my humble submission is Milords, this is no more res integra. That because of COVID, in 12(1) FF, you will not extend the time. That discretion they don't have. Milords, it is bordering on, Milords, I'll say bordering on kind of defiance of what has been observed. And we are placing the judgment. They can't even plead ignorance of the judgment of that order. And the Mid-East, the next case, Milords, which I'm trying to show, is the case of Orissa. The state government is fully aware that what has happened by the order of the apex court and exactly in the same situation, same conditions. Does any authority have this state authority, mines department, have this authority not to completely ignore the orders of the Supreme Court? So, Milords, kindly come to the annexure 6. Annexure 6, Milords?
Yes, it's there.
This is page 318. The date is, Milords, January 15, 2020. Date is important, Milords, because this order was passed before COVID had set in. The lockdown had not begun as yet. It is January 15, like Chogle one, which was passed on 30th January. Subsequent orders were passed when the COVID was at its peak, or we were all affected by COVID. Milords, I'm talking about this IA on the next page, 319, IA number 30915 of 2019. Milords, IA number, it is Messrs. Mid-East Integrated Steel Limited, here and after Mid-East seeks the following reliefs. Allow the application permit to applicant here to sell, Milords, this much of amount of this thing. Direct the respondent state of Odisha and issue transport permit. Permit the applicant here to deposit the entire consideration money received from the buyers to the state of Odisha towards partial satisfaction of the demand raised by the statewide demand notice 29/2007. Well, this is the notice, demand notice in light of the orders of the Honorable Apex Court. Pass any other orders, Lordship may deem fit and proper in the facts and case. Milords, para 7, I will not read the entire judgment. It will consume unnecessary time, Milords. It will be, Milords, at para 7, 1, 2, 3, 4, 5, 6, 6 line, Milords. Mid-East appears to have extracted mineral over and above what was permissible. Hence, per this court's judgment, 2817 in the lead matter, Mid-East was liable to compensate the state of Odisha for the illegal extraction. Milords, next line says the demand is 924 crores. Look, this is what I was citing. Yes. This is the case where they had not been able to deposit the fine as per the order of the apex court. So, Milords, that's why I say we are differently placed, but in a better position. Milords, last line. I don't know. Upon being unsuccessful, there have moved the instant application with the prayers reproduced above. Now, Milords, they undertake. That is also important. What will they do with the proceeds of this Mid-East? Para 10. Mid-East also undertakes to apply the sale proceeds of its stacked iron ore towards the demand raised against it by the state in order to simultaneously augment the state's revenue as well as reduce the applicant's liabilities. Now, Milords, kindly come to para 14. For the reasons stated above, IA number 30915 of 2019 is allowed and Mid-East is permitted to sell the iron ore already mined and stacked by before 1/1/2018 under supervision of authority appointed by the state government. This is a condition by the state government. They said that everything will happen under our supervision and everything will go to straight after the sale and purchase. The money will go straight to our. You will not be allowed to deal with that money. Now, my lords, this order.
Yes.
This order, my lords, I am reading. This order is of next annexure 7.
Yes.
This order is passed on 27th March. So this is 3 days after the lock-in has come in. So, my lords, the apex court was fully aware what has happened. They had filed an IA. By an order dated 15/1/2020, IA number 30915 of 219 filed by the applicants, Mrs. Bidist Integrated Steel Limited was allowed and it was permitted to sell the iron ore already mined and stacked by it before 1/1/2018 under the supervision of an authority to be appointed by the state government, subject to the sale process being deposited with the special purpose vehicle. The state government was directed to appoint the supervisory authority within 2 weeks and the sale process preferably be completed within 2 months. IA number 46039 of 2020 has been filed for extension of time, which was granted by the order dated 15/1/2020 by another 6 months. The applicant has stated that the supervisory committee recommended that the sale process can take place only on 24/2/2020, taking into account the reasons stated by the applicant and the present extraordinary situation of the lockdown. We deem it fit to extend the time granted by the order dated 15/1/2020 by 4 months after the normalcy returns, which would be from the lifting of the lockdown. Now, my lords, may kindly see annexure 8, which is the order passed on 24th November 2020. The IA number here, my lords, which is Midist's IA, is 101547. It is at the top of this annexure 8, IA number 101547. My lords,
no, which page?
This page is 327, annexure 8, my lords.
No, 27.
327.
27, but
327.
yes.
Annexure 8, my lords. This IA is for extension of time.
Yes.
We are in October. Lockdown has abated a bit, but COVID is going on. The worst phase of COVID is still to come, Delta COVID. These matters were called on hearing for today. This is the quorum. Finally, the order, the IA for extension of time is allowed. Time is extended by 6 months from today. So grant another 6 months. And my lords, I'll kindly see the IA, which is it. My lords, this order, which my lords has seen that they are disposing of the IA 101547.
Yes.
But since it's, my lords, it is a 2-line order, therefore we will have to see what was prayed in the IA to see on basis of which this time was allowed. So, my lords, that comes at annexure 10, which is at 340.
That we don't do, Mr. Singh.
Well, just to see why, what was the reason why they permitted the extension?
We don't see the pleadings. We just see the order which has been.
So I may be allowed to state. I may be allowed to state that, my lords, that we had talked in this IA.
Yes.
We had said about the COVID pandemic.
Yes, yes.
We had talked about the capping of number of vehicles.
Right.
We had talked about the constraints. And after looking at all these reasons, my lords, the apex court had granted us 6 months time.
Yes.
So, my lords, our humble submission here is that what is happening is that as the country is entering into COVID phase, and due to COVID, these extensions to lift my own ore was leniently being, my lords, being taken by the apex court and granted time in so many cases, and then extensions are going on, my lords. Sure. Let's now to consider and appreciate what was our representation before them and how did they dispose of. Because that's necessary to see that as per the directions, there were 2 directions of the Honorable DB. The first direction was that look at their representation carefully, see what case they have made out. Well, B, the direction was that in light of the discussion above, that these were the two directions. And third direction was also there, that go case by case, not go by. So, we will have to read what my representation was and what orders did what is the impugned order of the.
So let us see the impugned order.
It is.
Was what must have been your case in your representation that is understandable. What is the consideration?
No, because we had annexed everything and talked about the honorable apex.
Exactly.
We talked about the capping, the restriction on the vehicles, lockdowns, everything we had given. All reasons which are factual.
Let us see the order.
The order is 116, Annexure 1, page 116. Order begins on page 117.
Annexure 1 is the impugned order, right?
So
yes, sir.
This order is a little lengthy. May I read this? It's 117.
Relevant part.
Relevant part, first para I'll read. Ramesh Prasad Sao, erstwhile mining leaseholder of the Guwali iron ore mines over an area of 365 hectares. He goes into history of how he got the lease. There was a second transfer. The millets may come to the main. This is the lease details, how he's a lessee. So millets may not.
No, where is the discussion on 12.1 GG?
12.1 GG.
What is the opinion?
Millets. If we read some of the, very quickly I'll show that because he has said what grounds we have taken. So since we are not reading the representation, at least see whether he has taken, noted down. So may kindly see at page 122, para 9. The main contentions of the petitioner, 119. So this is the details of the lease, Milots. Para 5 also, renewal well within time. Extension of mining lease in para 6. 7 also. It is relevant to point out according to Rule 12.1 GG, the lessee may, after paying rent in 6 months, he gets 6 months. That is cited. Para 8, that on 4/10/2019, the state government of Orissa exercise of powers vested under Rule 10B. This is about giving the alternate site, Milots. I'll deal with the alternate site in detail because in their counter they have relied on that. We provided them an alternate site in October. But there's a long story. They give the permission. They do not provide the site. They give a permission that you can place it at a different location.
Amended the rules.
But Milots, my mines is surrounded by forest area, which I had given you the reasons. To find at least 40 to 50 acres of land to place my things, my iron ore was difficult. And then I had to get environment clearance. Nobody, not the government nor me, were aware that what is coming as a silent road roller, which is going to crush everybody, the COVID. We were about 4 or 5 months away. By the time we got all the clearances from the forest department, all the state governments, all clearances come, we had entered into the COVID. So my para 9 talks about that OMPTS rules. That para 10, he talks in order to restrict the spread of corona, the Honorable Prime Minister India called for a Janta curfew from 7 a.m. to 9 p.m. on March 22. That on 24/3 lockdown.
That's all about COVID-19.
COVID-19. Then the mining lease of the lessee expired in provisions of my lease expired on 31/3/2020. Talks about in para 12. Then Milots, the forest department gives me 6 months. Para 13.
Yes.
Para 14, that when transportation minerals from the existing stocks were to be started, the outbreak of COVID-19 and subsequent restrictive measures brought to halt all social and economic activities. Even though technically the transportation of mineral was not completely prohibited, the scale of activity, exodus and reverse migration of workers. So he has noted down what we had said. Restrictive and property orders issued by the agencies of the central and state governments. That there was complete shutdown and the movements of people, goods, vehicle and other traffic were brought to almost a complete halt for a considerable period of time. For an instance, it is relevant to point at the office of the collector and DM Koenjar. This is the district where this mine is located. While its order dated 5/7/2020 ordered a complete shutdown of entire Barbil municipal area with effect from 5 AM to 5/7/2020, and the said shutdown order was extended from time to time. So it was a day curfew by the order of the district magistrate. Though the shutdown order technically did not prohibit the transportation of minerals, however, the number of vehicles and the persons engaged in activity was severely reduced. Shutdown when nobody would come. That the transportation of minerals, which include loading, unloading, and host of other activities at the site of stock, and also at the site of destination of minerals, was severely affected. Then minerals on 17, that due to the lockdown declared by the government of India throughout the country, almost all economic sectors have been brought to complete halt. Epidemic Disease Act, ADA, and the Disaster Management Act 2005, all the activities, including the activity of industries related to industry dependent on requiring minerals, have been completely stopped. Concerned national highways. Such restriction imposed by the concerned and competent authorities of the Department of Steel and Mines, the number of vehicles allowed to be engaged in transportation of minerals have been severely restricted and capped, and the said capping order has been extended from time to time and it's still in operation, thereby severely curtailing and crippling the activity of transportation. Well, that's what we are trying to show here, that curtailment or restraint on me was put by the state. Though in the interest of general well-being, everybody wanted social distancing, COVID not to spread, to stop the number of deaths. But that constraint was not because of anything which I could control. And I had no option. When I say no option to not obey with these orders. We had to obey with these orders. And how can somebody down the line after 1 year say, no, there was no constraint. These orders are more than apparent that there was a constraint. 19, the transportation of minerals have been adversely affected also in view of the fact that the collector and DM Koenjar and Regional Transport Authority has issued directions to restrict the movements of heavy goods vehicles, including, that is, VR heavy goods, including those engaged in transportation of minerals. It is submitted that the collector had issued several restrictive orders in order to avoid heavy traffic jam and consequently inconvenience to the public and school-going children, movement of ambulance, movement of patients and daily commuters through the concerned state highway or national highway. It is pertinent to refer to the order. Para 20 minutes. It is further submitted that the permitted number of vehicles and permitted period of flying the vehicles were totally inadequate to allow the ex-lessees to complete the transportation of remaining stock. They have given also a chart showing dispatches of the ex-lessees under Paradeep, Gopalpur, Vizag, Haldia. This is the dispatch they did. That it was imperative of the ex-lessee to export the remaining stock of minerals. The ex-lessee exports its mineral mainly from Paradeep and Gopalpur ports. Unless it was a case-to-case basis, so my constraints should have been appreciated. The restrictions imposed by government agencies crippled the optimum capacity of ex-lessee and led to alleged failure on the part of the ex-lessee in removal of remaining stock of already extracted minerals lying undisposed in the subject leasehold area. A list of capping orders. Well, this is what they did. Well, the joint director passed an order whereby saying that 18/6/2020, 325 to Paradeep trips. You will not have more than 325. You will not have 174. If this is not constraint, what is it? Milots, which the Milots, the one? Milots, I'll come to the conclusion. The legal submissions were also given, which is at para 32 minutes. All those cases which we have, let's just show minutes. Minutes 160. No, उसके पहले से पढ़ना पड़ेगा. 5 minutes. 21 minutes. Minutes. And this is 12-1 HH. So he denies me 12 benefit of 12-1 FF, for which I have made a strong case by citing all these papers and the judgments. And then the rationale or the basis or the reasons which he gives of completely rejecting my case is a comparison between A and B. It is a case-to-case basis. B, data of evacuation plan. One first alternative, Malots, with cooperation from OMC was 6 months. And
3 months and 6 months.
3 months and 6 months. 6 months or 9 months. Check kar Milot will. No, Milots, that.
उसके 3 लाख उठाए.
Milots. May.
Pursuant to this one.
Pursuant to this. They rejected this. Then they passed that order, which is mandatory in 12-1 HH, which was passed on 24th May. And Milots, the little point, Milots, I would like to submit humbly, Milots, that giving of that 1 month is not under 12-1 FF. That's a mandatory under 12-1 HH. So no mercy has been shown to me as yet. Milots. Yes. Election page देखो ना उसका क्या है जो 12-24-5 का है which is at annexure 31 Milots, it's page 555. देखते रहो अच्छे हैं लोग 24th May. So Milots, in fact, very interesting now that Milots has come to that order. May kindly see that order, what they had done. Milots, in this is there's no talk of condition. Milots have appreciated 12-1 HH. It does not give any condition. When you are going to take away my property, after in a normal situation, 6 months are allowed. Then I give you 1 more month, which is a statutory period which they have to give when they are passing this notice, issuing that notice. And there's no talk of any condition. In this order, Milots may kindly see, which will also. Milots, the last line is very interesting. This notice on page 556. This notice under 12-1 HH of MCR 2016 granting time for a period of month will come into force from the date of submission of the undertaking as above. Milots, which High Court undertaking he's saying? In the previous line, with the condition that you shall give an undertaking to the Director of Mines to the effect that this annexure is 31 Milots. 31 H paid 555 Milots. 31. 31. It is on that notice on 24/5. So Milots, last para. Therefore, pursuant to the above order of the Honorable High Court and the decision of the Principal Secretary as communicated to you by letter number 40 dated 6/5/2021, that which we are talking about 5th May, you are hereby notified under 12-1 HH of MCR granting 1 month's time to remove all the balance material lying in the leasehold area, which were authorizedly extracted prior to the expiry of the validity lease on 31/3/2020, with the condition that you shall give an undertaking to the Director of Mines to the effect that you will abide by the final outcome of the orders passed by the Principal Secretary to ordered by the Honorable High Court in the above quoted judgment. My lords, in the above quoted judgment, my lords, the Honorable DB had said, in light of above, you take a decision looking at all the reasons which are they giving, and also said that abide by the decision. So, my lords, this he puts a condition which is never contemplated by the statutory provision. This order can go just on this, my lords. One of the prayers, two prayers which we have, main prayers. One is this is the another impugned order, the second impugned order, which we have prayed for quashing. My lords, he trying to put a condition that you will be given 1 month time. If you bind your hands and say that I will abide by your 5th May order, well, he will.
This hotel was subject to the condition that you abide by the order. If you don't abide by the order, which has been passed by the, it was passed under the order of the High Court, then this notification has no meaning.
My lords, because
Or if you want to have it, don't challenge.
my lords, I fully appreciate my lord's apprehension that is what will be argued from that side. But my lord's preemptive answer, my lords, is this, that any order passed by state government, any order, right or wrong, you can't say that you abide. That also by implication means don't go to court. I'm giving an undertaking. So we have challenges. But the little point I was making that statutory provision does not allow to, like in Melot's, I'm giving a very wide kind of example. In bail, conditions are put. In this 12(1) HS, there's no talk of any condition. He is not entitled by the statutory rules to put any condition, or he may put 100 conditions. So whether putting such harsh conditions is envisaged or not, that's an issue which may be taken up and decided.
Even before the High Court had taken a decision. So the basis there is that you take power without any order.
Which they did, and it was set aside.
Set aside, it was found. Yes.
So, my lords, this is the notice which he had passed on 24th May. My lords, now his page 152, my lords, this is his on page 152, my lords, has para 37. He begins the analysis of everything which I have written and my lords submitted. May I read this? My lords, this is this analysis where I have been hung, my lords. By this analysis, I have been hung on the ceiling. So this has to be read how this order has been passed, whether they consider. My lords, may I read? Page 152, my lords. This is the impugned order, para 37. On analysis of the above of the facts and contention of the petitioner lessee, along with the facts on government record, the findings are as follows. 38. That there were 24 mines, including the one belonging to the petitioner lessee, whose validity expired on 31/3/2020. In accordance with the provisions contained in law, all these 24 lessees, including the petitioner lessee, were covered under the purview of Rule 12(1) GG and Rule 12(1) HH of MC Rules 2016. By virtue of the respective lease deeds, validity of which expired on 31/3/2020, all these 24 mining lease holders knew very well, almost 2 years in advance, if not more, that their lease would expire on 31/3/2020. The state governments, visualizing that petitioners' right might not be in a position to transport the whole minerals stacked on the leasehold area, on consideration of representation of the instance of their association, issued notification dated 4/19 and provided each of them the scope of intermediate storage, and with a further additional period of 2 years up to 31/3/2022, with permission to sell all such minerals in the open market. Hence, all the lessees of these 24 mines, including the petitioner lessees, are covered under the purview of Rule 12(1) GG and Rule 12(1) HH of MC Rules 2016 by virtue of their respected lease deeds, validity of which, it is like ABCD, EF, GH. GH, I remember. F, I start my counting from G. Rules 21 GG and Rules 212 HH of MC rules by virtue of the respective lease deeds, validity of which expired on 31/3/2020. The lessee is also wrong in his interpretation that the provision of MCR 60 inter alia are applicable to his case. After the amendment now, MCR 2016, his lease is governed by the provisions of the present provisions. He was mandated to look whether there was a constraint or not. He was mandated that it can't be the case of the government that there was no constraint. The Honorable DB said that COVID had brought the country to a grinding halt for 3 months. What he has done. So we'll just read the orders.
That while passing the order in the light of this court's order, the secretary was required to keep in mind the reasonings given by this court. So if they have not been taken into account, we will see. We will read the order and.
So may I read 39?
Not required, Mr. Singh.
Well, just I wanted to show that it is comparison of equal versus unequal. The national chart, the growth in import or export.
That you said you.
Some annexures he has added to. He has annexures put 5 annexures. It's very important to see all those because he has based his logic of denying me completely on basis of those annexures, which are in my favor. So he puts data on those annexures, which are in my favor. And then he takes advantage of those data. So, Milots, that has to be seen and appreciated.
Like
Milots, like Annexure 1. Milots, kindly.
Annexure 1 of that.
Milots, Para 41. Para 41, he has discussed and substantiated his logic or reasoning by Annexure 1.
Just a minute. Yes.
Page 154, Milo?
Yes.
Para 41. That it is worthwhile to note some statistics which are very relevant to establish whether and to what extent the dispatches of ore were adversely affected due to the conditions emanating from the various restrictions imposed on account of COVID-19 lockdowns. The total dispatch of iron ore from all the above 24 mines has to be to the tune of 25.53 million tons post-expiry as per the tabular statement enclosed under Annexure 1. Taking the data of the total dispatch of iron ore from all the above 24 mines.
Yes, this 41 we have understood. After having
Annexure 1 will have to be seen.
Yes. So the finding of the secretary is again in paragraph 53, of course, based on that discussion.
Now,
53.1. 53.1 it says that Ah, 52. That inability to evacuate the entire stock from the mine. This is what the secretary has opined. That it is not because of the pandemic, but because of your own inability. So this 12.1 GG, according to the secretary, is 12.1 FF, sorry, is not at all applicable in your case, according to his the secretary.
Well, it's my humble submission is to see the complete lack of logic in the reasoning which he has given to reject my claim.
We will see.
We will see. So, para 41, let me read and then show the annexure.
Is it required, Mr.?
Well, it is very much required. Those annexures, the 5 annexures,
yes.
The conclusion he has taken out is totally contrary to the figure which he gives.
Yes.
So that has to be seen, Milots.
Yes.
So, Milots, I first read 41, then I'll show annexure 1 and Milots. May I read it? that it is worthwhile to note some statistics which are very relevant to establish whether and to what extent the dispatches of ore were adversely affected due to the conditions emanating from the various restrictions imposed on account of COVID-19 lockdowns. The total dispatch of iron ore from all above 24 mines has to be the tune of 23.53 million tons post-expiry as per the tabular statement enclosed under Annexure 1. Taking the data of the total dispatch of iron ore from all the above 24 mines whose lease had expired on 31/3/2021, the total dispatch has been to the tune of 23.53 million tons after expiry of the lease and within the permitted timeline as per the tabular statement Annexure 1. That the said tabular statement further indicates that the cumulative dispatch from all the 24 mines has been maintained at the level of 2.5 to 3.0 million tons per month from April 20 to 2022. This is indicative of the fact that dispatches were going on unhindered by similarly placed lessee located in the very same geographical area and location. If dispatches were adversely affected, owing to the various restrictions imposed on account of COVID-19 lockdowns, it would have not been possible for other similarly placed lessee to dispatch their minerals at such levels. Now, let's kindly see page 161, Annexure 1.
Yes.
Yes. We are at serial number 11.
Yes.
RP Saw. And this shows the lifting in April.
Yes.
Wait a second. Opening stock is there in
which item?
Milots has 161, page 161, Annexure 1.
Yes, yes.
Serial number 11, Milots.
Yes.
RP Saw.
Yes.
So, Milots, we have lifted 76 in April, 164 in May.
Yes.
Then it increased 4.39, 5.36, 4.7, 4.97, 6.42. And Milos, what has to be noted is the whole chart has to be seen. He's talking about 24 leaseholders. The highest offtake is from serial number 16. Milos, has that seen? Rungta Mines Limited.
Yes.
So we have done 28.30 lakh tons. They have done 51.96 lakh tons.
So according to you, your ability has been considered by them as inability.
Milots, the effect...
Because you have been compared with Rungta.
One point, Milots. The first point is that Rungta has the railhead within the railway siding within the lease area. So you can't compare apple with pear. A. And B, that out of all this, we are the second highest lifter. And the impact of COVID, is it not visible? 76,000, 1,60,000. Then we tried to consolidate, but still the constraints were there. All those cappings were there, numbers were there. So the chart which he's trying to give here, and Milots, several other Milots, what he's saying, suppose Milots kindly see 19, when he's comparing, 24 log hain, 22 to अच्छे थे, आप ही सबसे खराब हैं. Kindly see Milots, this serial number 19. He has 3,444 tons. How can he be compared to me?
All right.
So this is what I'm saying, Milots. He's trying to give a logic by a chart, basing logic by a chart, which does not make sense. It doesn't make sense to me. This is illogical.
It's illogical.
He's trying. Milots, data hide more than what they reveal. It depends on how you try to project that data to prove your point. Milots, what he's trying to say is obviously not correct, Milots. Now we come to the next annexure, Milots, which is also the conclusions are as sans any logic as in the annexure 1. Let's para 42. That the mine-wise comparison of the dispatch figures in the said tabular statement further indicates that 19 lessees have planned the monthly dispatch so as to able to evacuate more than 90% of the total stock of ores lying as on 31/3/2020. Further, monthly dispatch from one of the mines has been maintained at the level of 0.7 million tons, that's Kurungta, indicating that there has been no bottleneck for transportation of minerals during the period in question, as is being made out by the petitioner. A simple look at the annexure X enclosed with this order would make it clear that while lessee like Rungta Mines and Aryan Mines and Trading Corporation were dispatching in the range of 4 to 7 lakh metrics per ton on an average, the present applicant was dispatching only in the range of 1 to 1.5 lakh tons month during April to June and picked up dispatches only from the month. A figure which shows my constraint, Milots, is being put as if to blame me. This point to the lack of seriousness on the part of the petitioner in taking up dispatches in right earnest and in compliance to the rules. The main edifice of the argument of the petitioner is based on the grounds of invoking force majeure provisions of 12(1).
We will see, Mr. Singh, we will see the entire, the manner in which the statistics annexure 1 has been addressed.
Well,
by
I'll just take 5 more minutes, Milord. I'll just show the chart and then see what he's trying to show, Milord. Kindly see, Milord, the annexure 2.
Yes. Yes.
ये तो annexure 1 ही है. Milords, before, kindly see page 162, Milords.
Yes.
Milords, if Milords had seen, then April or May, I had gone down to 76,000. And they give the figure in April 19, Milords, at serial number 11 again. Milords, has that? I am again at serial number 11, but the figures are of 2019-20.
Yes.
So, Milords can see that in April in 2019, I did 5.74. And in April 2020, I did 76,000, which I had sold, Milords. So 5 lakh tons less, no effect of COVID, no constraint. His own data is showing that my dispatches went down. So all this figure to justify 22 people were lifting. Some people have thousands of only a few thousand tons. So they will obviously lift within 6 months, even if they go at a slow speed. So let's now kindly come to annexure 3. Annexure 2.
Yes.
Page 163, Milords.
Yes, it is there.
So, Milords, here also, the month-wise domestic purchase of iron ore, which is showing a decline from June 20, July 20, August 20. And Milords, the best annexure 3, Milords, on the same annexure on the next page, which is page 164. Milords, if Milords has 164. In May, Milords, kindly see. In 2018, it is 110,48,364. In 1920, it is 150.
Yes.
And then it is 83 in May. In April, it was 120 in the previous, it is 76 in 2021. Again, actual dispatch. Milords, kindly see, in month of April 1920,
yes,
101,65,507. It's almost cut by 40%. 64, 52, 635. Milords, the next page, annexure 4. It is at page 165. Milords, the first column says 1920, progressive production dispatch, iron. The first chart is of iron, the rest is manganese, bauxite, chromite, coal, total, etc. Milords, kindly see of iron. In 1920, the 40,000, 40.300. In 2021, which is the COVID
the
period.
crux of the matter, Mr. Singh, is that according to them, based on whatever statistics they are relying on, there was no effect of pandemic. So
according to them,
your requirement to
invoke force majeure,
your requirement to lift the minerals which you had extracted. So that was that, despite the observations made by the High Court, despite the findings recorded by the High Court, according to the Secretary, the pandemic did not affect you. It was because of your inability, not because of the circumstances, that you could not lift the minerals. So this is the
very concisely put, Milords. Just one little thing which I wanted to add, that the figures which he has given in the annexure 1 to 5 completely demolishes the logic which he gives.
The reasoning based on, according to you, the reasoning based on that is illogical.
Well, so I pass an order and I say, look at this chart. He has been running very well. You have not been running well. And this is the reason. And then I say that I was running slowly because of COVID. Your data says that. And then you say no effect. That is what I'm trying. So the order is not based on facts and figures even given by him. Forget, my lords, my grounds given by me, not even given by him. It is not based on that. So he cannot support on wrong data, wrong analysis, wrong reasoning, ignoring the orders of the apex court, not my lords, taking into account the observation of the division bench, and just pass an order and say, I'm binding you, abide by this, or I will not let you even give you 1 month. And no friend on my.
Thank you.
Obliged.
Yes.
Item 2, my lord.
So, Mr. Subramaniam, will you address? You are in which case?
I'm ready, my lord. I'm in the 4th item.
4th item, then
Item. Yes.
you can begin, Mr. Subramaniam.
Certainly, my lord. My lord, the case has 3 points.
Yes.
And my lord, they are substantive points.
Yes.
The first, my lord, is that the order which has been passed by the government does not show that it started reasoning on a clean slate.
Yeah.
In other words, it is not reconciled to the fact that the orders of 1st of October 2020 and 9th of October 2020 were quashed. My lord, when an order is quashed, it ceases to have any effect. And your lordships will notice that when we look at this order, it goes back to the period of 31st of March 2020 and the calculation of 6 months from then. The division bench, my lord, in fact, remitted the matter to the state government with, my lord, some careful words, and I, my lord, quote from the judgment, to a stage anterior to Rule 11(1) stage.
Yes.
Now, anterior, my lord, to that stage must necessarily mean that you first have to apply your mind to the question of force majeure, keeping in view a certain sense of weight which the judgment of the division bench has imparted to the pandemic and the resultant circumstances. Now, my lord, has that exercise been done with that spirit as mandated by the court? Has it been done on the basis of individual lessees and their circumstances? Or, as my learned friend Mr. Singh showed, that all the lessees, my lord, were lumped together. And, my lord, an omnibus analysis is made that, well, there has been movement of mineral ores during this period. Therefore, force majeure need not be attracted. And because force majeure is not attracted, even that 6 months should not be given under my lord GG. Let me straight away come to HH and give 1 month with that undertaking. But that undertaking is no more than an undertaking not to file a case. That's about it. It's not, it can be disregarded because, my lord, such an undertaking cannot be proffered in law at all. But, my lord, the first point is, what is the real intendment of the division bench judgment? Was it adequately heeded when the matter went back? And, my lord, in my case, now, my lord, take my case. In my case, my lord, I happen to be the old lessee whose lease expired on the 31st of March 2020. And if your lordships, my lord, will kindly note a date. On 2nd March 2020, I am also, my lord, the new lessee with whom there is a letter of intent. And, my lord, I plead with the government and say that I am now the new lessee. I am the old, but I'm also the new. Why do you want me to take away the ore, which I might use for manufacture, and the machinery, just for the sake of satisfaction of a rule, when I am actually the new lessee in situ? So, my lord, what does the government do in my case? It allows me to keep the machinery. It says that is a fair point, that you are the new lessee. You will need plant and machinery. So you please keep plant and machinery. But as far as the ore is concerned, you are placed at par with all other lessees, because 6 months is counted from 31st of March 2020. Then, my lord, we tell the government that even ahead of 31st of March 2020, the state, my lord, conscious of Rule 11.1 GG, namely that the ore, my lord, is intended to be removed with the plant and machinery, because it is for the benefit of the lessee. Because, my lord, it is his ore, it is his plant, it is his machinery. So, my lord, the state government, in exercise of powers of relaxation, issued an order, which I'll show you, my lord, shortly, on the 9th of October 2019, permitting intermediate storage depots and, my lord, time to dispose of the stocks were extended till 31st of March 2022. So, my lord, my client said, well, being a new lessee, I can't be worse off than all these gentlemen who have time till 31st of March 2022. I am the new lessee for 50 years. The lease, my lord, has been executed with me, and that date, my lord, is very significant, 8th of July 2020, even before the expiry of 6 months. And, my lord, this order, therefore, with great respect, my lord, seems to visit the lessees with a punishment for having challenged that original premise of that 12.1 HH order. My lord, why is it that the division bench quashed that order? I must tell your lordships this. The order of 1st October 2020, my lord, is an order under 12.1 HH. That is that last 1 month notice. After 8 days, my lord, they pass an order rejecting the application for force majeure on 9/10/2020. And the division bench said that this is complete non-application of mind. Because first is 12.1 FF, as my lord the Chief Justice observed. Then comes 12.1 GG, that is, my lord, that mandatory period of 6 months. And then one period of ultimatum, which is 1 month. And by relegating back, my lord, all the lessees to a position prior to 12.1 FF rejection orders, my lord, everybody needed their cases to be considered individually. And if there is no individual consideration, my lord, for instance, my client, my lord, he has referred to 11 orders which actually prevented transportation. Now, my lord, is it an answer to say that some other lessee was able to transport? It is not suggested, my lord, that my reasons are incorrect. It is not suggested that there were no embargoes on transportation. It is not suggested that there was no capping on the number of permits. None of these, my lord, is factually denied. In fact, my lord, in our representation, we pointed out that all the material placed before the division bench, which your lordships will notice in the judgment, is referred to as Annexure 10 series, 11 series, 12 series, 13 series in the judgment of the division bench, my lord. That is the preponderant evidence of COVID and its impact. My lord, the court said that this is something which is called force majeure. My lord, the state raised an argument exactly before the division bench that there is no force majeure. They argued the same point, that people are still lifting, there is no force majeure, there is no impact of COVID. My lord, the same argument was repeated before the division bench and it was rejected by the division bench in express terms. Therefore, my lord, I submit that this order falls foul of the division bench judgment. It does not translate the mandate of the judgment. And, my lord, there is a sheer misunderstanding and misdirection, a legal misdirection in the matter of interpretation of the rules. My lord, these rules, the most important part, my lord, of this rule is the caption of the rule, my lord. The caption of the Rule 12, it says conditions of a lease. If your lordship sees the title, Rule 12, it starts with conditions of a lease. These are statutory conditions. They are not simply contractual conditions. The title, my lord, your lordships will notice, is conditions of
conditions.
Yes, that's right. And my lord, therefore, if these are statutory conditions, they bind the state, my lord. There is no question of discretion. There is no discretion involved. They bind the state. The state has to observe these terms and conditions. And my lord, in our respectful submission, the order proceeds upon a state of denial of COVID, as if COVID had no impact. My lord, if one reads this order, it will look as if COVID had no impact at all. It seems to suggest that iron ore could still be mined, iron ore was freely transported, iron ore was required. But my lord, that is not the test for force majeure. The test is, could a person lift his oar under these circumstances? My lord, every lessee has pleaded reverse migration. People, my lord, went back to their villages under trying circumstances. There was no public transport available. My lord, no one can forget these realities. And my lord, what is the comparison? My learned friend, Mr. Singh, when he referred to those 5 annexures, my lord, they are slightly hilarious that someone has compared 2019-20, 2021, financial year 2019-20. My lord, what does that have to do for these 8 months? Does it have anything to do with these 8 months?
But Mr. Subramaniam, if we accept all the submissions which have been advanced by you and Mr. Singh, what should we do? Again, another remand.
No, my lord. I straight away ask your lordships to please look at 2 rules, GG and HH, and pass an order. Pass an order which is applicable to all.
No, it would be beyond our jurisdiction.
No, my lord. I'm saying, my lord, please direct the rules to be followed. In other words, if your lordships are satisfied, my lord, there are 3 possibilities. One is your lordship is satisfied that as far as this 12(1) FF is concerned, there has been non-application of mind. But I understand, my lord, your lordship is exercising powers of judicial review. I understand your lordships are not being asked to substitute your own opinion or own judgment in a matter relating to force majeure. My lord, there would necessarily have to be a remit if it is a question of force majeure. But my lord, what do all the lessees want? My lord, they are not going, my lord, no one is being deprived of money. For the removal of this ore, royalty will have to be paid. My lord, please take it. Whatever ore is going to be removed and sold, royalty will follow. The state will be paid royalty. There is no concession which is being shown except, my lord, accommodation by way of time. But, my lord, there are 2 kinds of lessees. Lessees who are no longer the lessees, but who still have their mineral. They must have a fair time, my lord, a window of whatever time your lordship considers, which doesn't go past, shall we say, that period of 6+1 in the 2 sub-rules, GG and HH. But, my lord, for the person who is actually a lessee in situ, my lord, these rules also can't apply because the person is entitled to use his plant and machinery. my lord, if a person has been the highest bidder in an auction, like my client, my lord, he has bid, he has secured, and the lease deed is executed even before the expiry of 6 months, then, my lord, I should be allowed to use the machinery which has been granted, and I should be allowed to keep the oar and use it, sell it, and if I sell it, remove it, I will pay royalty. My lord, this is actually a case which is only calls for a simple solution. Because, my lord, all these pages and paragraphs in these orders, your lordships will find, are all hinged on one fact, that the lease expired on 31st March 2020. You should have known the letter of the law that you had only 6 months. You should have actually removed your oar. And if you have not removed it, then 1H will apply. And we did put 1H, but the High Court asked us to consider it. And, my lord, the best way actually to pay obeisance to a judgment is quote large paragraphs of it in inverted commas, because it will show as if the person is alive to what is said. My lord, the para about in the light of our reasonings is quoted. But what are the reasonings in the judgment have not even been capitulated in the order. Your lordship will not find any place in this long order passed by a senior officer, even a summary of the conclusions in the judgment. But, my lord, relevant paras are quoted in full, in verbatim, to show that there is compliance with the judgment. But when one, my lord, looks at it closely, my lord, it is shorn of reasoning. It passes, my lord, the test of reasonableness. It completely, my lord, fails the entire exercise. My lord, it is completely misdirected. And, my lord, if your lordship say go back to a stage anterior to 12.1 FF, the person begins with an a priori assumption that there is no case made out under FF. But now, if you don't get FF, you don't get even GG. You have to just go and go within a month. And, my lord, in all cases, very quickly, they said even the property is vested in the state government by virtue of 12.1H. My lord, that is completely extreme. And, my lord, the real intendment, if I may say so, the real intendment of Rule 12.1GG, my lord, is for the benefit of the lessee. It is a beneficial intendment. My lord, has that beneficial intendment been considered by the government? In fact, my lord, the government has equated the expression remove the ore and the machinery to dispose of the ore. Your lordships will find, my lord, this equivocation in the order. Removal, the word used, my lord, in the rule is removal of the ore, the machinery. And this, my lord, has been equated by the government with disposal of the ore in the market. And, my lord, what is the reason said against me? It said that people who were not fortunate to get a new lease were compelled to sell some of their ore. But you have been able to get actually a new lease. Therefore, why should you get any benefit? My lord, I think when your lordship reads the order, it will have some moments of humor, my lord.
Which page?
Yes, please see, my lord, the order. If your lordships will find the order, my lord, my writ petition, my lord, is 18741.
Yes.
And if your lordships will kindly see, the order, my lord, is to be found in Annexure 15. And I'll start, my lord, straight with the, shall I say, my lord, with the quintessence of that order. Please come to the operative para, because that itself will tell you, my lord, that's printed page 353 of your lordship's paper book.
Just 353.
Yes, I'll show you from the operative directions how much of an error has been attempted. 353, my lord. That's the last
632 of the
18740, man.
Yes, 18740.
Yes, we're there.
Yes. Does your lordships have printed page 353?
Just a minute, Mr.
Yes, certainly, certainly.
18740. 8740. 61632. Share 15. Connection 15.
So I'm taking you, my lord, straight to the concluding portion.
Yes.
Because that itself will demonstrate, my lord. Therefore, in view of the discussions as above, and after careful consideration and analysis of all facts and circumstances, I hereby dispose of the representation with the order as below. The prayer of the petitioner, Sirajuddin and Company, the holder of mining lease of Balda Block Iron Ore and so on, over an area of 335 hectares, for allowing extension of time as permitted and availed by him under 12.1 GG is not maintainable and thus rejected. My lord, your lordships have pushed us back to 12.1 FF. How can he deny me 12.1 GG? But my lord, let us look at the next, Roman 2. The petitioner lessee may not be insisted upon to remove plant, machinery, and other equipment from the leasehold area, subject to the submission of the written request letter from him to the effect that the same will be required by him for running the mine. Now, my lord, how does one apply one part of the rule and omit the other part of the rule? He allows me to keep the plant and machinery because I am the new lessee, but I'm supposed to take away the ore. If your lordships now see the rule with me for a moment, my lord, just see the rule for a second. Your lordships will find 12.1 GG actually uses it, my lord, in one line, straight line. Please see, the lessee may, and my lord, I'm cutting out the first 3-4 lines, may take down and remove for its own benefit all or any ore mineral excavated during the currency of the lease, engines, machinery, plant, building structures. So, my lord, the ore and the plant and machinery is treated together for the purpose of GG. And GG, I say, my lord, is not applicable to me because I'm the new lessee in situ. I was the old, but I'm also the new. And I already have a lease deed in the same area, my lord, for the same extent of land for 50 years. 50 years. And, my lord, that is why in the order your lordships notice at that page, in para 77, Roman 2 he allows, because I'm a new lessee. In the previous portion of the order, my lord, he says, because I'm a new lessee, I allow you plant and machinery. But, my lord, if you allow me plant and machinery, why should I not use the ore? Why should I not actually keep the ore? Why should I not, if it is, my lord, in my case, it is low-grade ore. I can refine it. I can find a proper buyer. But how, my lord, can the GG stage be passed like this? And then please come to Roman 3. The petitioner lessee may be allowed to remove the balanced mineral ores lying in the leasehold area, which were authorizedly extracted prior to the expiry of the lease validity, subject to invoking of 12.1 HH of the mineral concession rules by the state government. So, my lord, he goes straight away to that 1 month period. And then Roman 4, my lord, this is important. My lord, my client was paying the highest royalty irrespective of the grade of the ore. So, my lord, the sampling and stacking was exempted by the state government. Then, my lord, I actually appealed to the state government, please withdraw your exemption, because the ore which I'm producing is so low that I cannot pay the maximum royalty and sell it in the market. Please withdraw the exemption. My lord, no action on the application. On the main order, my lord, with reference to stacking and sampling, he says this ground is untenable. But now, my lord, please see Roman 4. He allows the application to be considered. The withdrawal of exemption from stacking and sampling as prayed by the petitioner may be examined by the Director of Mines as per law, an action as deemed proper will be taken by him. My lord, I have just read 4 conclusions from an order. And is there consistency, my lord? That is the short point. And when your lordship looks at the body of the order, in the body, please see, my lord, he gave permission for sampling. Your lordships have seen that, Roman 4. He said it will be considered. But please see, para 74 at printed page 351. I'm showing you, my lord, errors apparent on the face of the record, which are errors. Please see para 74. Next issue to be examined is whether delay in grant of permission to the petitioner lessee for stacking and sampling by withdrawing the exemption for stacking and sampling allowed earlier by the Director of Mines is a just reason which acted as an impediment in timely and faster disposal of minerals by the petitioner. My lord, my applications were pending. My applications, my lord, were pending for months together. No decision was taken. Let us understand the process of grant of transit permit in case of stacking and sampling which the petitioner had prayed for. A lessee prepares stacks of ore of not more than 4,000 metric tons. After making stacks, the lessee collects samples of the ore and applies for chemical analysis. The samples are taken by him to the government chemical laboratory where the grade of ore is tested. After the results of chemical analysis are reported, the concerned authorized officer issues transit permits. Generally, this entire cycle takes a minimum of 1 week to 12 days, excluding the time taken to prepare the stacks by the lessee. Now, against this, the petitioner had availed from exemption from stacking and sampling. That is history, my lord. I have sought its revocation. Then, this implies that the petitioner was neither required to prepare stacks nor was required to collect samples and get it analyzed in government chemical laboratory for ascertaining the grade of ore. And then please see, my lord, over the page top. It is therefore not appreciated as to how the petitioner would have dispatched faster if his exemption from stacking and sampling had been withdrawn in time. That this delay in withdrawal acted as an impediment is misstatement of facts and false. But your lordship has seen direction Roman 4. He wants that application for withdrawal to be considered. This is one example. My lord, let me show you another example. Please see for a moment on the issue relating to my being a continuing lessee. My lord, that is indeed something to be seen, my lord. Please come to printed page. Your lordships will find printed page 340. Para 54. That there are 24 mines.
Just a minute, just a minute.
Sorry.
You are referring to 314 printed page.
340, my lord. 340. 340. Please see para 54, my lord. That there are 24 mines, including that of the petitioner lessee, validity of which expired on 31st March 2020, that as per the provisions contained in Rule 12.1 GG and HH, the lessees of all the above 24 mines, including the petitioner lessee, are covered under the purview of 12.1 GG and 12.1 HH of the MC rules by virtue of the respective lease deeds, validity of which expired on 31st March 2020. Now, please see, my lord, the next paragraph. That at the very outset, it will be appropriate to examine the claim by the petitioner as to whether the petitioner was in any manner differently placed than the other ex-lessees whose mining leases had expired long with the petitioner, and whether the provisions of Rule 12.1 GG and HH were applicable to the petitioner or not. Upon scrutiny of facts, it is clear that the petitioner was one of the 24 lessees whose mining leases had expired. He therefore is equally placed with all the other 23 lessees. Thus, the provisions of 12(1) GG were applicable to the petitioner. Like every other lessee, the petitioner was mandated to remove the minerals lying within his lease area within 6 months as per the provisions of 12(1) GG. All these 24 mining blocks were put up to auction by the state government. Thereafter, now, my lord, this word thereafter is non-application of mind. It is not after the expiry of 6 months. In July 2020, the lease deed was executed. Thereafter, the petitioner won the very same mining block in the auction and was declared the successful bidder. My lord, I was declared the successful bidder on 12th March 2020. The lease deed is executed in July 2020. The vesting order is 4th of June 2020. And my lord, then see the next sentence after that. The issue here is that the law provides that the ex-lessee is to dispose of his old stock. My lord, does your lordship notice the word dispose? This is not the word in the rule. The word in the rule is remove. Dispose of his old stock within the prescribed time of 7 months, 6 + 1, under 12(1) GG and 12(1) HH respectively, merely because the petitioner became the new lessee also for the self-same block does not qualify him to be extended any benefits beyond the law. My lord, what is that benefit beyond the law? Under the lease deed, which I'll now show you, my lord, I'm entitled exactly to the rights of the previous lessee, but I'm a continuing lessee. And please see the next sentence. If any extension of time is granted to the petitioner on the grounds that he is the new lessee and the mineral is not causing inconvenience to any other new lessee, would imply granting undue and unlawful benefit to the petitioner. My lord, I'm saying no one is prejudiced. There is no new lessee who is waiting on the wings to take over the possession of this area. Therefore, I am not causing any inconvenience, any prejudice. And he says it is unlawful. Disposal of stocks has been done by other similarly placed lessees within a short window of time. My lord, is this relevant? Is this a relevant consideration in law? Is disposal of stock by a lessee?
Continue tomorrow, Mr. Subramanian.
Certainly, my lord, certainly.
Sorry, day after tomorrow.
Day after, my lord.
At same time?
Tomorrow at 2 p.m.
Certainly.
2 p.m.
Your Lordship,
Grateful,
item
Lord.
35, learned senior counsel had mentioned in the morning today for fixing up a date. Item
Which
29 and 35. 29
25, the chairman made a mention in the morning.
and 35.
The prayer is going to be taken about 22nd. 22nd at 2 p.m. The Lordship please.
22nd of October.
Second, after that is
22nd of
reopening the conversation now.
this man made a Tuesday. This
Yes.
is not this.
Tuesday, 28th,
May I only pay them 4th of November?
Yes.
4th of November only.
4th of November
Fourth.
at 2 p.m.
Both the
4th of
20,
November.
At 2 p.m.
39 also.
Lord,
Both the matters he has mentioned.
Item
Which are 20.
25
See,
and
again,
39.
if you are making the same prayer, that because lawyer is common in both the cases should be heard together. No. If the issues are common, yes.
item 28, my lord, interim order to continue.
I can have it fixed on 5th also.
Okay.
39 can be fixed on 5th also.
Item 28, my lord. Interim order to continue, my lord.
Which?
Item 28.
All right. In all the cases,
Item 20.
just a minute, in all the cases where interim orders are there, just give the slip. Those interim orders shall continue. Is therefore I'm saying that is black.
I mean, Parliament that yesterday's matter item 27. 27.
3rd of October.
Yes, 3rd of October.
2 o'clock.
27. Yesterday's last item. It was supposed to take in, my lord, because that interim order could not be extended sometimes.
Interim order was not there.
Yes, my lord, I am sorry for that, but
No.
my lord knows the how that position.
Yes.
We know.
So you want
Day after tomorrow, my lord.
just make a mention on
3rd.
on 3rd. We'll see what can be done. We will expedite. Today, Miller, some nursing and pharmacy matter have been picked up today, Miller. We are not so much concerned for pharmacy matter because the time limit is extended by the Honorable Supreme Court and my senior friend. Please make a mention in the morning on 3rd. On 3rd, make the matters are listed or not? Yes, Miller. All the matters shall be listed on 3rd.
Yes, my lord, all the matters are listed. All these nursing and pharmacy matters have been listed. Item numbers of my lord I have given.
All right, all the matters shall be listed again on Thursday. If there is any urgency, please let us know.
Pardon to mention.
13 your lordship is pleased to fix on 5th of November.
Pardon to mention, my lord. This is a illegal detention and custodial torture case.
Yes, the matter was directed to be listed today. What happened?
It was
Called.
Huh?
It's the picture of the
Is there an item number 19?
item number 18.
18, and my friend yesterday,
Yes.
in fact, he has been arrested, he has been forwarded to the court, he has been remanded to jail custody yesterday only, Lord.
All right.
A case under the Bihar and Orissa Act, and he has also got antecedents. I've got the detailed information.
It's beyond 24 hours he was detained in the custody.
All right, don't talk to him. You have to address it. All right. We will take up. Now you are under judicial custody.
Lordship,
So there is no,
for medical treatment, Lordship.
maybe medical treatment that can be seen later.
Yes, he never complained before the magistrate.
Who hurt whom is yet to be seen because you are under the excise.
Lordship may be taken after day after tomorrow.
It's there in the list. All the matters will come day after tomorrow. You make a.
My lord, in item 31.
Yes.
In item 31, my lord, my candy, keep it to.
All right, we will see later.